A father convicted of killing his infant son is back in court 20 years later because the science that put him in prison may no longer exist. Luther Garner was found guilty in 2004 based on expert testimony about shaken baby syndrome, but now, in 2026, that same expert has recanted, and a new generation of doctors is being asked whether the diagnosis itself was ever valid. This post-conviction hearing will determine whether Garner deserves a new trial based on what the state once called definitive medical evidence.
All right, let the record reflect that the applicant, Mr. Garner's here, Ms. Filbert, Mr. Udishin, Mr. Coleman, and Ms. Shield are all here. Before we get started, Mr. Coleman, with your first witness, is there anything that we need to take up this afternoon?
Nothing to state, Your Honor.
Your Honor, I do have one thing. The next few witnesses, certainly this first one from the state, have in their affidavits reference to other children that there was an allegation that Mr. Garner had done something to harm. And we do considering those other children on several bases. First of all,
Your Honor, I'm sorry, we concede that. We won't go into that.
Okay, perfect.
I already planned for that and anticipated this objection.
Okay,
all right,
that was easy.
That was
good job. Thank you, Mr. Coleman.
Yes, ma'am. I will say that I have 3 of my 4 expert witnesses here. I don't know if the court would like to do your normal practice like we do with the jury trials, swear them all in at one time. I suspect Mr. Udishin will be invoking the rule, so.
Yeah, I will invoke the rule, except as to Dr. Edwards.
Sure.
We already agreed on that.
Okay, so yeah, we'll just get them all 3. Everybody can come up and I'll go ahead and get that out of the way. Good afternoon, everyone.
Yeah.
You'll please raise your right hands. Do you, each of you solemnly swear or affirm that the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And so the rule is invoked. Dr. Edwards, you're welcome to stay. For the others, you're obviously going to have to sit outside, not listen to any other testimony. Don't watch anything. It is on YouTube, so don't pull it up on YouTube. And don't discuss your testimony with anyone other than lawyers or investigators.
There is one other thing, Judge, it may benefit these witnesses to hear how you rule on this. While I'm not going to delve into the involvement of CPS, I planned on asking a question about how the child Kalen was discovered, and the baby was discovered by a CPS caseworker in distress. That was the extent of that I plan on going into that.
That was part of the underlying
Yeah.
facts of the case that I read in the transcript. So I don't see any issue with if it's in the if it's anything that was presented in the trial itself, then I think that is within the limits. If it's not, then I would say it's not, other than scientific or new medical evidence.
And Your Honor, obviously that's correct. There was some testimony concerning one of the other children in the punishment phase of the trial. And I understand that's what Mr. Coleman's not going to go into or assert.
I would, anything else?
No, ma'am.
All right, thank you. Y'all can step outside other than Dr. Edwards, you can remain in. Anything else?
No.
And Mr. Coleman, which one are you, and you want to go ahead and
At this time, state of Dr. Michael Yu.
all right, Dr. Yu, come on up, sir. We won't make you walk out and walk back in.
Thank you.
You can have a seat. And is the light on that microphone right there on the left side?
And what?
It's already on, perfect. Okay, you may proceed, Mr. Coleman.
Thank you, Your Honor. Dr. Yu, please state your full name for the court reporter and spell your last name. Please.
Yes, my name is Michael Yu, M-I-C-H-E-L, last name spells Y-U.
And Dr. Yu, how are you employed, sir?
I'm currently assistant clinical professor at the University of Texas Medical Branch.
And let's talk about your background just briefly. Are you board certified in general pediatrics?
Yes,
And what about in child abuse pediatrics?
I'm board eligible.
Meaning at some point, or are you planning on?
Getting board certification? Yes,
When is that exam coming up?
next week.
Have you completed a child abuse and neglect fellowship?
Yes,
What did that entail?
3 years of bedside treatment of patients with suspected maltreatment. That also included research and also doing other scholarly activities.
And you mentioned your duties as a professor. That's at UTMB, Galveston
Correct.
Branch.
Yes,
And that's as a clinical professor. Explain really briefly for the judge what that means, being a clinical professor.
So that's a mixture of doing patient work and also doing education, teaching medical students, teaching other residents and faculty members about my field.
And in addition to that, you're also a director or the director of the ABC team, the child abuse team there at UTMB, correct?
Yes.
And the child abuse team, what do they do?
So we evaluate patients with suspected abuse and neglect issues, and we also do the foster care clinic.
All right, oh, very good. And did you, I don't recall if you said or stated the year that you graduated from medical school, did you?
That will be 2019.
2019. And of the 4 expert witnesses that the state intends to call, you are undoubtedly the most, the youngest and the most recent grad, correct?
Yes, from what I know, yes.
All right. And is it fair to say that the other witnesses have at least a couple of decades, maybe more on you as far as experience?
Correct.
And I'm not saying that to be flippant or in jest. I'm saying that to say that you would have been of the 4 the most recent to graduate, the most recent to have undergone training in medical school as it relates to diagnosing and treating shaken baby syndrome and or abusive head trauma as it relates to infants, correct? Did you or were you asked by our office, the district attorney's office, to review a file, criminal case file related to a deceased 2-month-old by the name of Kalen Garner?
He would have been around 11 months when he deceased, but yes, I reviewed Kalen Garner's files.
And just to be clear, if you recall, and if you need to review your affidavit or whatever materials you brought with you, when he ultimately died, he was 11 months or thereabout.
Correct.
When he sustained the injury leading to his death, how old was he?
He would have been 2 months.
Okay, good. And you reviewed that information that was provided to you. Do you recall what that information included?
Yes.
What did it include?
So it included court testimony from the Garner case back in the year 2003, included medical records from multiple hospitals, included therapy notes from when the child was discharged, other hospitalizations, his autopsy, and witness statements, and other files.
Ah, very good. And approximately when did you review these records?
Around January, February.
Of this year?
Yes.
All right. And included in that information, did it reference a discovery of Kalen and his state when he was discovered?
Yes.
What do you recall about the discovery?
So a CPS worker went to the home unannounced when she knocked on the door. The caregiver of the child.
I'm sorry to interrupt, but that would be Luther Garner, correct?
Yes.
The defendant in this case?
Yes.
All right, please continue. I'm sorry.
No problem. Luther Garner opened the door and told the CPS worker that he thought his child may need to go to the hospital.
Okay. And the state that the child being Kalen was in, what did the records reflect in that regard?
The records reflected that he was not responsive.
Do you remember any other detail about this condition other than just being non-responsive? If you recall, sorry.
He had altered breathing patterns, so what we call apnea. He would not blink whenever the CPS worker was trying to snap her fingers in front of his eyes. That's what I can recall.
And the defendant, Luther Gardner, essentially acknowledged his awareness of this to that CPS caseworker, correct?
Yes.
And as a clinical practitioner and someone who's trained in recognizing abuse in children, what, if anything, in your training and experience would that be indicative of as far as, I can ask it a better way. Someone in that situation who doesn't immediately seek medical treatment for a child in obvious distress.
Objection, Your Honor, it's irrelevant. Sorry, objection, Your Honor, relevant regarding the new science. This is concerning other.
That's overruled. Obviously, part of what I'm to take into consideration is the underlying other factual circumstances surrounding it in the trial and other evidence when I make my ruling. So I'm going to allow to go down that path to some extent. Thank you.
Thank you, Judge. We were talking about your training experience as it relates to recognizing abuse in children. What does your training experience tell you or indicate to you about someone who would delay seeking medical treatment in this particular situation?
So a delay in care would be suspicious for non-accidental.
Eventually, Kalen was taken to the hospital, correct?
Correct.
Taken to the hospital by the CPS caseworker.
Yes.
And a CT scan, at least the initial CT scan, what, if anything, did it indicate?
It indicated widespread swelling of the brain, what we call brain edema.
And if at any point, if it's helpful for you to review your affidavit, please do.
Okay.
But my notes indicate that you put in your affidavit, quote unquote, massive brain swelling, in which it may be parsing words here, mincing words, but you said widespread. I just want to make sure we're clearly in your affidavit. You said massive.
Correct.
All right. And what does massive brain swelling, in addition to the delay in seeking medical treatment, again, in your training experience, at least initially, what is that indicative of?
It'd be concerned for some type of trauma.
Also noted in those records was a bulging fontanelle. Is that how it's pronounced?
Yes, bulging fontanelle.
Fontanelle. Is that the front part of the infant's head?
So that is on the top of the head, kind of towards the front. That is the spacing between his skull.
Does that indicate an increased, and that pressure, intracranial pressure, would be caused by what?
It can be caused by a number of things, such as bleeding. It can be caused by tumors, meningitis, increased brain swelling, a number of different things.
And in the process of treating Kalen, did the records indicate that tumors were ruled out?
Yes.
In the process of treating Kalen, do the records indicate that meningitis was ruled out?
Yes.
Yesterday, during the testimony of Dr. John Galaznik, he mentioned a differential diagnosis. Is ruling out, for instance, tumors, ruling out, for instance, meningitis, is that part and parcel, or is that part and parcel of a differential diagnosis?
Yes.
Differential diagnosis, your understanding of it being what?
So differential diagnosis is looking at the symptoms and coming up with a list of medical reasons for those symptoms.
And coming up with a list of those medical reasons for the symptoms so as to rule out
Other diagnoses.
And along with the differential diagnosis, I mean, the long and short of it is you don't have some checklist that you're working with when you're looking to evaluate, diagnose, and or treat abusive head trauma in infants, do you?
There's no checklist. There's a workup, but there's no things we check off.
So in other words, someone suggests to you that there's a quote unquote triad, and if you get these three things in the triad, then you guys stop investigating or stop diagnosing or stop ruling things out.
We do not stop.
Just to be clear, if someone suggested that this triad consists solely of looking for subdural hematoma, retinal hemorrhaging, and an altered mental state, you reject that notion, correct?
I would reject that notion.
I mean, they could be part of the diagnosis, is that fair to say?
Yes.
But it's not that you.
Your Honor, I'm going to object to leading.
I'll do a better job, Judge.
All right.
But I'll say this, Judge.
Here's the thing.
It's medical testimony. It's hard.
Yesterday was, and there wasn't an objection, but it was, and think it helps probably all of us to get through it to allow some leading. And so I think it's only fair that there's going to be some. So I'm obviously be careful with it, but I'm not going to say no leading whatsoever with this type of hearing.
We're talking about the triad and whether or not you just, once you've got those three things, you shut it down. Is that the case? Your notes also, or your affidavit also indicates that there was a documented loss of neurological function, correct?
Yes.
What other procedures were performed on Kalen as a part of his treatment overall?
So once he was transferred to Texas Children's, there was concern that he was not able to breathe on his own. He would not be able to eat on his own. So they put tubes into his trachea and his stomach so that he can maintain some oxygen support and some hydration and nutrition.
So this 2-month-old baby had a tracheostomy.
Gastrostomy.
Ostomy, thank you.
Yes.
And that brings me to my next point. If I get any of these terms wrong or mispronounce them, feel free to correct me, please. Let's talk about the retinas. What, if anything, was noted with regard to the retinal examination?
That there was bleeding to the back of his eyes, that the retina composes of many layers, and that there was bleeding in all 3 layers, and that it was not only found in the center of the back.
The exclusionary rule you just saw invoked, where witnesses must leave so they can't hear each other testify, is designed to prevent testimony from being shaped by what others say. Under Michigan court rules, this protects the integrity of evidence, especially critical when scientific opinions are being tested. Here, it also reveals the stakes. 3 of 4 defense experts are being kept apart from the state's fresh-faced pediatrician, whose 2019 medical training may carry more weight than decades of experience.
Back of his eyes, but extended to the periphery.
What's commonly referred to as extensive and multiple layered, correct?
Yes.
Why is that noteworthy?
Because when we're looking through our differential diagnosis for retinal hemorrhages, there can be many causes for retinal hemorrhages, but for multi-layered, extensive, diffuse retinal hemorrhages, trauma is the only cause.
Just to be clear, trauma is the only cause for multi-layered, extensive, in distribution retinal
Hemorrhages in kids.
hemorrhages in infants. And I mean, while there may be other causes in adults, correct, or other causes in older individuals, when we're talking about infants, is that the case?
Yes.
Okay. Was an EEG or an electrocephalogram?
Yeah. Electroencephalogram.
It's what you said.
Yes, it was done.
What was determined as a result of the EEG?
So it was determined that there was no seizure activity on the EEG.
Was a subsequent CAT scan done on Kalen?
Yes.
As it relates to the oxygen, the level of oxygen, what, if anything, did it show?
It showed injury due to a lack of oxygen to his brain.
What's referred to as anoxic?
Yes.
What is that, generally speaking, indicative of?
That's indicative of some type of loss of transport of red blood cells perfusing oxygen to his brain tissue.
Was there also atrophy of the brain? Now, the case materials that you reviewed, did it also include reference to the fact that this defendant gave varying accounts to law enforcement about what happened?
From what I reviewed, there were 3 statements he gave, and each statement contained more and more details about the events that happened that day.
The triad of injuries Dr. Yu describes: brain swelling, bleeding between the brain and skull, and retinal hemorrhages, has been the diagnostic cornerstone of shaken baby syndrome prosecutions for decades. What makes this testimony pivotal is that the defense is challenging whether this triad can still be considered definitive proof of intentional abuse, citing newer studies suggesting alternative explanations. Under Michigan's post-conviction relief rules, Garner must show this scientific shift would likely change the trial's outcome.
Again, in your training and experience, much like the delayed seeking of medical treatment, the multi-layered retinal hemorrhaging and widespread diffuse nature of the retinal hemorrhaging, what does giving different accounts or varying accounts of the patient history, what is that in conjunction with all those other things indicative of?
That there would be concern for non-accidental trauma.
Particularly with regard to someone who is the sole caregiver. Would all that information be considered part of what's referred to as the patient history?
Yes.
And you, as a clinical practitioner, when diagnosing at least the potential for abusive head trauma in an infant, you consider patient history as well, right?
Yes.
And is that the way that you were taught? And was that part of your training, your medical training as well? And then you understand from the records that the ultimate version that the defendant gave to law enforcement was what happened, and what did he represent to law enforcement ultimately happened to the baby?
So he said that day that he woke up late, he carried Kalen, and he hit his head against the doorframe. The dad said that his eyes rolled back and he was not responsive. To stimulate him, dad said he shook Kalen to get his attention. Father was able to give Kalen a bottle. They both went to sleep. And after the nap, after dad woke up from the nap, he was unable to wake up Kalen.
So eyes rolled back, he became non-responsive, but nevertheless, is there any indication in the file that the defendant sought medical treatment for this 2-month-old?
No.
In fact, do you have a time frame from between, or an estimated time frame between when this alleged or purported door frame injury happened and the eye roll and unresponsiveness, from that time to the time that the CPS worker made the unannounced visit and discovered Kalen? Do you have a approximate time frame?
So my approximate time frame was that the hitting against the door frame happened around sunrise. Then they took the nap and dad woke up around 10 or 11 a.m. and the CPS worker came to the house around 2 p.m.
Not seeking any medical treatment during that. Forgive me if I missed it or if you said it, but did he admit to any shaking of Kalen at all at some point?
Yes.
And what was the account that he gave, or the version that he purported to law enforcement?
That to stimulate his Kalen to wake up, he shook him.
What you practitioners refer to as resuscitative shaking, or is that a term that you use or have heard before?
I've heard of it.
Is there a limit? Let's say we buy this version that the defendant gave. Is there a limit on the type of resuscitative shaking that someone could give before causing an injury?
There could be.
And in fact, while we're talking about these versions and what was represented in law enforcement, is there any indication in the file that there were any independent witnesses of this door frame hit or of this resuscitative shaking?
No.
Does the file indicate essentially that I'll move on. Are you familiar with the studies that relate to the shortfalls, the theory associated with them, at least that's relevant to this case? In summary, for the judge, what do they stand for? I don't want to spend a lot of time on it, but I think it's important in light of the testimony from yesterday.
So shortfalls are.
The timeline here is devastating. Approximately 8 hours between the alleged accident and any medical attention, with the infant unconscious for hours before a CPS worker discovered him. In shaken baby cases, this delay often matters more than the mechanism itself. Prosecutors argue a genuine accident prompts immediate 911 calls, while abuse leads to cover stories and waiting games. The resuscitative shaking admission becomes the prosecution's anchor. Even if the doorframe strike happened, the shaking confession remains.
Are most of the time defined as less than 5 feet in length. That they've done studies that from kids that fallen out of hospital beds, and very few sustained major injuries. By major injuries, I mean like skull fractures, concussions. None of the children's in these studies had altered neurological status, such as disordered breathing, loss of consciousness to the point that they in the future couldn't take food or air by mouth.
And you mentioned the studies, and is it fair to say that not all studies are created equal? We have case studies, and then we've got clinical research studies, correct?
Yes.
We've got studies that look retrospectively, we have studies that look prospectively, correct?
Yes.
We have studies that are published, studies that aren't published, right? There can be studies that aren't published.
Correct.
And for the ones that are published, they are published under different publication guidelines by different organizations. Is that fair to say?
Yes.
Explain to the judge what your understanding of a case study. What is that? What does that represent?
So case study is getting a bunch of different events and describing each event in detail, and then drawing some kind of conclusion from those series of cases.
What about a clinical research study? And I know there's some nuance to it, but generally speaking, I'm talking about either a prospective clinical research study looking back, or a retrospective looking back, or
Yeah.
prospective looking forward, involving a group, a cohort.
Right.
Explain to the judge what we're dealing with in that instance.
So in those cohort studies, you identify a population with some kind of feature, and you either go back in time or you follow them over a period of time and seeing how if an event happened or how they develop after an intervention.
So in summary, to be kind of summarize this, a case study can focus on an individual or individuals, small group with some unique or features. And a clinical research study, either prospective or retrospective, can focus over time with a group, typically maybe a larger group,
Correct.
of similarly situated individuals who are studied over time, correct?
Yes.
And your experience, which is more intensive, which is more authoritative, which is more detailed, either a case study or a clinical research study.
So it would be a cohort study that would be more high powered than a case studies.
And when you say cohort, and again, I know there's nuance to this, but when you say cohort, you understand that's what I'm referring to, at least generally, globally.
Mhm.
So
As a clinical research study.
as a clinical research study.
Yes.
And is that your testimony that, at least globally speaking, a clinical research study is more authoritative, more detailed, more intensive than a case study? Which bucket would you put these studies, these various studies about shortfalls into? The bucket of case study or studies, or the bucket of clinical research study? The majority of those case studies.
Well, the ones that I mentioned from the they looked at it following of hospital bed falls, those would be a cohort study. There are certainly other shortfall studies that are case series.
And kind of piggybacking on the testimony of Dr. John Glasnick yesterday, it was his testimony that there are hundreds of case studies out there as it relates to abusive head trauma in infants. Is that, would you agree with that statement?
I wouldn't say infants, but definitely children. Kids older than infants included.
The science, as it was, well, let me ask you about those studies. Have you reviewed studies that, in your opinion, you thought, well, it would appear that the author of those studies had demonstrated some bias or some bias in their study?
I had some concerns with their study designs.
Have you reviewed case studies in which you formed the opinion that someone who authored that study was perhaps advancing a narrative or an agenda that they wanted to advance?
I was concerned, yes.
I'm not saying that that's the case in this particular case, but is it possible, of those hundreds of case studies as it relates to shortfalls, that someone could, for lack of a better term, cherry pick case studies that advance the narrative or asserts the opinion that they want to advance or assert?
Yes, there's a concern.
Let's talk about the science behind the shortfall theory or hypothesis. Yes, ma'am.
So I know I cut this short yesterday, I thought, about shortfalls because there is no allegation of shortfall in this case.
And here's where I'm getting at, Judge, and I'm going to touch on this a little bit briefly, is the notion of the rebleed and the clotting, particularly as it relates to the venous thrombosis that was alleged yesterday. And that's kind of the shortfalls kind of touch on, is that there can be a minor injury.
The defense's strategy emerges clearly. Undermine the scientific foundation of shaken baby syndrome by attacking the quality of research supporting it. By distinguishing case studies from rigorous clinical research studies, Attorney Gilbert attempts to show that much of the medical consensus rests on weaker evidence than juries are led to believe. Dr. Yu's admission that some studies show bias and can be cherry-picked opens a crack in the certainty that convicted Garner in 2004.
Causes a rebleed or a clot.
Explain to me, though, how that I still don't get where the shortfall is relevant.
Yesterday, Dr. Glasnick quoted or testified that there is an alternate potential theory as to the injury. And I just want to explore the fact that the alternate potential
Which was the head on the,
would argue is not unlike, it could cause that type of an injury, what would appear to be minor, but later on causes what he testified to as a primary injury that leads to a secondary injury that ultimately leads to the baby's.
I would just make sure when I'm okay with that as long as when you're questioning that relationship between what you're talking about, the relationship between the shortfall and you're saying, or the expert saying the head of the door jam.
Give it to me again, Judge.
That was not very clear. I get that. I just need, if we're going to talk about shortfalls, I want to make sure it's not just what you're saying, but that the expert is relaying to me that there is some similarity or could be between the potential injury from the door jam and the science behind the shortfall. Otherwise, I don't think it would be relevant.
Yes, ma'am.
Does it make sense?
The science between, you've heard the exchange between the judge and I. The science, if you pull back to like a 30,000 foot level, essentially, and I say science, the hypothesis or the theory essentially says.
So in my field, all kids that in the case studies that, in the research papers that I've cited, all these kids who had shortfalls did not die.
And the theory, I guess what I'm getting at is, if you pull back 30,000 foot level, the argument, the theory, the hypothesis is that it's because it's a shortfall, it's not necessarily a massive injury, or cause a massive injury, but a minor injury that leads to a secondary.
All the kids who had minor injuries did not have the massive injuries later.
And I think you and I are talking past each other. You're telling me what your understanding of the result of the data, where the studies are. What I'm trying to get at is explain to the judge the link between why you and I are even talking about shortfalls when there's no shortfall in this case alleged, but a minor striking of the baby's head on the door frame.
Right.
So what, if any, link is there between a minor fall and a minor striking of the head on the door frame?
So that is, the link would be that both have some type of impact to the head.
And the impact to the head would not necessarily be, help me with the term, you guys use type terms like crush injury, you use terms like.
So that it will be a direct impact injury.
But not necessarily severe.
Correct.
Okay. And that's the link. A door jam strike on an accidental door jam strike on a door frame.
Yes.
Is not unlike a minor impact from a shortfall, in that the theory or the hypothesis is a minor strike or impact to the head could result in a secondary.
A minor hit to the head would not lead to major injuries.
Yeah, that's the conclusion. I get it. That's what you're concluding. But the argument is, at least for those people who purport the shortfall theory or hypothesis, is that it could. That's the argument, right?
That's the argument.
And the argument would be, at least for the sake of our discussion here, that a door frame impact is not unlike a shortfall impact. That's the argument. You obviously, in your answers, you don't agree with that.
Correct.
Okay, good. Now, again, this is a theory, this is a hypothesis, but has this in any way, if you accept it or reject that hypothesis or theory as it relates to shortfalls, has it changed the underlying science, the science of diagnosing, of the science of identifying and or diagnosing shaken baby syndrome or abusive head trauma in infants? Has it changed that science?
Has not.
I mean, because that still remains the same, right? You're still looking for those same, you're still performing that same differential diagnosis, looking for those same things you've been trained in that identify shaken baby syndrome or abusive head trauma in infants. You're still looking for those things, but what's been purported with this new shortfall argument, hypothesis, theory is a different mechanism of causing the SBS, the shaken baby syndrome, or the AHT, the abusive head trauma. Is that fair to say?
That is fair to say.
And can it be misleading when someone says, well, there's new science as it relates to shaken baby syndrome and or AHT, abusive head trauma? Can that be misleading?
Yes.
I mean, because again, to put a finer point on this, we're not talking about anything that changed the diagnosis of short baby Freudian slip. shaken baby syndrome or of abusive head trauma in infants, that science hasn't changed, just the hypothesis that leads to the argument of a new mechanism that caused the injury. Diagnosis available back in 2000, the diagnosis as it relates to the science of shaken baby syndrome or abusive head trauma in infants.
So the diagnosis of sinus thrombosis was available back in 2000.
And we're gonna get to sinus thrombosis, but I'm just talking about the science as it relates to shaken baby syndrome and abusive head trauma in infants. The science as it is today was the science as it was back in 2000 is what I'm getting at.
Yes,
The only thing that has arguably changed is the hypothesis, the mechanism of that causes that science, right?
correct.
So, I mean, I guess, and not to be a dead horse, but instead of new science, maybe the appropriate term would be new mechanism of injury. Let's talk about a 3-month-old child. It goes without saying that a 3-month-old child is immobile, right?
Yes,
Meaning what?
that they cannot crawl, they cannot walk, they cannot stand.
And that's important, particularly in this case, because if there is arguably a shortfall, and there's a sole caregiver, what necessarily follows?
That they would know that the child has fallen.
That they would know that the child's falling, which would mean that
Okay, we're gonna stop talking about falling.
oh, you know what? I fell right back into that. I didn't mean to.
Yeah.
I'm sorry. Let's talk about the conclusion that you reached. You indicate what you call concerns. Is that essentially your conclusion, or what do you?
So my conclusion is that given his symptoms of brain swelling, bulging fontanelle, multi-layered diffuse bilateral retinal hemorrhages, that there is a traumatic cause to his injuries, and that without a history of trauma that explains the injuries, that there is substantial concerns for non-accidental trauma.
And give me that list again. I neglected to add that to my outline. Given the brain swelling, given the bulging fontanelle, and what else did you list there?
The multi-layered diffuse
That's the
bilateral retinal hemorrhages in an immobile child, that trauma would have caused these injuries. Without a history of trauma to explain these injuries, there are substantial concerns for non-accidental trauma.
So we're talking about all of these factors went into your consideration when you reached the conclusion or determination of abusive head trauma in this particular case, right?
Correct.
That's the brain swelling, that's the bulging fontanelle, the nature and characteristics of the retinal hemorrhaging, the immobile nature of this 2-month-old child, and the as you put in your affidavit, the inadequacy of the child's. All of this went into your calculation. And do you have any doubt that this would have been the same evidence that would, or information that would have been presented to the jury for their consideration?
Correct.
Okay. I want to be clear on the answer because I know I worded it wrong. Do you have any reason to believe that this information would not have been submitted to the jury?
There is no reason.
Okay, good. That's okay.
Objection, he's not a legal expert, he's a medical expert.
I'm not asking him for a legal conclusion. I'm asking him if there's any information that would indicate that this information he testified to didn't make its way to the jury.
Does not make
Well-
decisions on prosecution. Your Honor.
No, well, I guess we already know what was given to the jury. Did he read that transcript?
Yes, ma'am.
Okay, so overall, I mean, if he read the transcript from the trial, then he would have that information.
Now you mentioned the inadequacy of the patient history. What makes it, in your opinion, inadequate?
That there's no substantial traumatic event to lead to these injuries.
At least that was reported. I think you beat me to my next series of questions. You already kind of recapped those findings when you summarized the brain swelling, bulging fontanelle. Part of the information you reviewed was also the findings in report of Dr. Fernando Stein, correct?
Yes.
And you also reviewed the findings and information provided by Dr. Patricia Moore.
Correct.
And as they listed them at that time, do you agree with their conclusions?
With which ones?
Let's take it specifically one at a time. with regard to Dr. Stein, he concluded that violent shaking, and I'm quoting here, violent shaking of the body with anterior and posterior movement of the head multiple and repeated times caused the brain to shear the neurons and get swollen and to bleed behind the eyes. Would you agree or disagree with that assertion?
The prosecutor's Freudian slip moment saying short baby instead of shaken baby actually reveals something important about how these cases get discussed. Dr. Yu's testimony here establishes a crucial distinction that courts struggle with: the difference between diagnostic science, what injuries indicate, and causal mechanism, how they happen. Under Michigan's post-conviction relief rules, a defendant must show new evidence that would likely change the outcome, not just new theories about the same old facts.
I would agree with just adding an amendment that said violent movements that can include shaking.
Okay. And he also characterized those movements as fast acceleration and deceleration forces, namely to the head back and forth rapidly. Would you agree or disagree with those conclusions based on the information that you read in the file?
Yes.
Dr. Stein, you understand from reading his information, was a pediatrician at the time with Texas Children's Hospital ICU unit. Is that your understanding of this position?
Yes.
A practitioner with more than 25 years experience, if you recall that from reading. I don't want to put words in your mouth.
He's a pediatric critical care doctor. I don't know how long he was practicing, or I don't recall.
Correct. In your opinion, in your medical training, who's best suited to opine about diagnosing and treating shaken baby syndrome and or abusive head trauma in infants? A clinical practitioner who diagnoses it and treats it in order basis, or someone, for instance, like a biomedical or a law professor?
I would say a physician that's doing clinical care.
Now, we've talked about whether or not you agree with Dr. Stein's findings and determination. Let's move on to Dr. Moore. At the time, Dr. Moore concluded some type of direct force to the head, whether it be a shaking mechanism, was involved. Would you agree with that or not?
Yes.
She also went on to say that there was some type of acceleration injury that caused as she characterized it, the quote unquote problems in the brain and in the eyes of Kalen. Based on the information that you read in the file, would you agree or disagree with that? She said that when asked, during her testimony, excuse me, in the transcript, it indicates that when she was asked if the injuries were consistent with a closed head trauma due to shaking, her answer was yes. Would you agree with that?
That is a possibility.
Okay. And she also, during her testimony, stated that the effects of that trauma would be immediate. Let me just read it. When asked if it would have had an immediate effect, her answer was yes. Now, what's your take on that?
So I guess what is an immediate effect? So effects can be a range of symptoms, such as crying, such as irritability, to seizures, to blacking out. So effect is a range, but there.
You've also provided us, the state, which is also, I believe, on file, your affidavit. Is your affidavit essentially a summary of your testimony here today?
Yes.
If you've got your affidavit in front of you, I'd like to direct your attention to a specific paragraph.
Okay.
It's on page 3, paragraph 4. You reference the age of Kalen, and if I'm not mistaken, you got a typographical error. And I just want to point that out. You reference him as being 4 months old.
So that was the other child.
Okay. Well, let's not talk about the other child.
Yes.
I'm sorry. Okay. I may have misread your. Let's move on and talk about your fees or what you charge our office, the state, to provide your consult and ultimately your testimony. How much is that, or was that, or how much is it?
It is $250 and it's paid to my employer.
Okay. And it also includes the payment for your expenses, correct?
Yes.
Expenses, correct?
Yes.
Is that unusual for that type of work? And is that essentially common practice for consulting of this nature for this type of a matter?
Yes.
And has that payment or payments or reimbursement for your expenses in any way influence your testimony you're taking?
No.
In fact, have you signed well, do you have any interest in the outcome of this case otherwise?
No.
In fact, have you signed a conflict or a disclosure of any conflict?
Yes, I signed for.
Before we go to my outline here, let's talk, well, we've already talked about this, the studies, different types of studies. There's other thing that I'd like to point out. We talked about a little bit yesterday in cross-examination, the publication process with the American Academy of Pediatricians. The judge heard a little bit about it. I don't want to spend a lot of time on it, but you're familiar with the guidelines, right?
I'm familiar with some.
And there are guidelines involved, and that provides reliability, next layer of credibility. Is that fair to say? Let's talk about, there was testimony Dr. Glasnick provided yesterday that essentially equated shaken baby syndrome or abusive trauma in infants with the presence of a broken neck, rib fractures, and or in your training and in your experience. Does that always come in brain injury or shaken baby? But just to be clear, can you have an injury, a significant injury, is shaken baby syndrome or abusive head trauma in an infant that does not come with either a broken neck, a rib fracture, or ligament? I mean, how is it possible?
So, how is it possible to have a brain injury without ligament damage or broken ribs?
Yes, sir. I mean, generally speaking.
I mean, all kids, right? It depends on how you hold the kid, if you shake them, the positioning of the head, hands. There's a lot of different factors.
I spent a little bit of time on biomechanical modeling. That was some subject of some testimony yesterday. And are you familiar with any, if at all, limitations on biomechanical studies or modeling as it relates to shaken baby syndrome or abusive head trauma? And
Yes.
the core, what those limitations are.
So, obviously, with our patient population, you can't do studies involving participants because of the violent nature and harmful effects of them. So people have tried to use computer technology, coding. They try to use monkeys, but using those models, you can't replicate the exact human composition to everything. So there are limitations of creating the perfect model.
Essentially, crash test dummies in animal studies aren't necessarily an apples to apples comparison. Also, those biomechanical studies, is it fair to say, they rely on calculations and data. Let's take this case, for instance. We would not know, an unknown would be the amount of force that was being used or exerted on Kalen, either with regard to the impact or with regard to the shaking. That's just something that could not be calculated, correct?
Correct.
And that would affect the modeling or the hypothesis, correct?
Yes.
Another thing that can't be calculated is the frequency. There is an unknown with regard to how many impacts or how frequently, how the number of shaking or acceleration or deceleration. That's just not, even if you took the defendant's version at face value, you still could not calculate the amount of force. You can't calculate the repetitive nature, if any. Let's talk about intracranial venous thrombosis. Yesterday, Dr. Glasnick theorized that a plausible alternative in this case is or was an epidural hematoma that led to an intracranial venous thrombosis. I had to look this stuff up. Epidural hematoma just flipped.
So it's a type of brain bleed.
And an intracranial venous thrombosis. And his theory was that the epidural hematoma set for the secondary injury of the intracranial venous thrombosis. Let me start with the most obvious thing that I think, at least, is would there at least be evidence of an external impact?
There was an external impact. There could be, but in this case, the external impact could be like a bruise. It could have been covered by the child's hair, but there was no evidence of external impact in all the medical notes I reviewed.
Did you see any evidence of a transverse sinus thrombosis?
So in the medical records I reviewed, which included radiology reports, there's no mention of any epidural or sinus thrombosis.
Who's most qualified, a determination CT scan? What I'm getting at is, while pediatricians may review it in order to determine if they need to consult, but ultimately, would a neuro-radi
The $250 fee disclosure matters more than it appears. Prosecutors routinely ask experts about compensation to preempt defense attacks on credibility. Jurors and judges often suspect paid testimony. But notice Dr. Yu's answer. The money goes to his employer, not his pocket. This distinction helps courts evaluate whether financial incentives actually bias testimony, a factor Michigan courts consider when weighing expert reliability under evidentiary standards.
biologist be the most qualified to testify as to what's contained in the CT scan?
Yes, that would be fair to say.
Are you familiar with the 2025 AAP reaffirmation of the science, underlying science of shaken baby syndrome and abusive head trauma that was authored by Dr. Narang and Dr. Lindbergh?
I'm familiar.
Just generally speaking, when you hear the name Sandeep Narang, which have you formed an opinion as to this individual?
Yes,
What is that opinion?
he is very scholarly. He's both a doctor and a lawyer, so he's an MD, JD, and he's published dozens and dozens of research papers.
And he co-authored that 2025 reaffirmation with Dr. Daniel Lindbergh, who's also an expert witness in this case. You were here today. You were here today with Dr. Daniel Lindbergh, right? And last question for you, Dr. Yu. The theory behind the diagnosis of shaken baby syndrome and abusive head trauma in infants that to this day remains generally acceptable by physicians who frequently encounter child abuse. Is that a first statement?
So it is not a medical controversy at all in the medical field.
Good afternoon, Dr. Yu. My name is Kalen Garner. I'm one of Mr. Garner's attorneys. Excuse me. Okay, I want to touch on a few of your qualifications again, just briefly before we get into your review of the case. So you mentioned that you're a board eligible child abuse pediatrician or clinician, and you will be taking the boards in a few weeks to be certified.
Yes.
Okay. And you're currently the director for UTMB's child protection team.
The child abuse program.
Child abuse program. Okay.
Yes.
And that team includes a board certified pediatrician with child protection.
Are you referring to me?
The team, yeah, the team's makeup. Are you in a clinical practitioner position?
Yes.
Rather than administrative? And is this today the first time that you have testified as an expert regarding a case of suspected abusive head trauma, shaken baby syndrome?
So I've testified as an expert and I've testified in abusive head trauma before. I cannot say with confidence if I was qualified as an expert in that case. But I have testified before in abusive head trauma cases.
Okay, you've given testimony in court.
Yes.
Right, and you've given testimony in civil cases as well, or primarily criminal?
The prosecutor is building a wall of institutional credibility. By highlighting that the 2025 American Academy of Pediatrics reaffirmation was co-authored by an MD-JD who publishes dozens and dozens of research papers, he's telling the judge, this isn't fringe science, it's mainstream medicine. The MD-JD detail matters. Narang speaks both medical and legal fluently, making him harder to dismiss as a partisan witness.
Criminal and CPS court.
Makes sense. Have you ever presented any sort of on the topic of abusive head trauma and the diagnosis procedure?
Yes.
Have you ever published any papers on that particular topic?
So I have one publication. Yes.
It's The Tale of Two Cities it was an AAP publication, or is it different?
Yeah.
All right, and the prosecutor discussed with you that you reviewed the trial transcripts, medical.
Yes.
And then you also reviewed law enforcement records. Did you review any of the investigative records or state
Like the police notes or
investigators' notes or the defendant's?
I I reviewed the defendant's statements with the detective, yes.
The investigative report was, I think, maybe 13 pages total, so it's pretty short. You could have missed it. Did you review any of the other experts' post-conviction affidavits?
Like which ones? Dr.
Dr. Edward gave an affidavit.
So I think I saw a rough draft, but not his final draft.
Okay, and there was also a post-conviction affidavit of Dr. Moore, the pathologist who testified. Did you review her 2023?
Yes, that one.
Okay, so you're aware she's recanted her testimony.
I don't, from what I read, I don't believe she recanted all of her testimony. I think she recanted some of her timing of her statements as to the child's injuries.
Okay, well, we'll get back into that in just a little while. I want to go through some of the historical facts of the case now. So you would agree, we're on the same page here, that no one indicated, there's no witness statements of any independent, sorry, let me rephrase that. You agree that there's no independent witnesses that saw Mr. Garner abuse Kalen Garner, right?
Correct.
And that's by shaking,
Correct.
that's by impact,
Yes.
that's by any other means. And all we really have on that fact is we have his account memorialized in his trial testimony, right?
Yes.
And we have his statements to law enforcement, right? And in those, he never admits to intentionally shaking his child in an abusive manner, right? And noted abusive.
There's no account of him shaking him violently.
And he only stated in that statement to law enforcement that he shook the child after he became non-responsive. Isn't that right?
That's in his statements, yes.
Okay. And it was because he consistently also said in testimony in his statements that he thought his son was okay after that event that he described with the door impact, right? And that's because his child stopped crying.
That's because the child stopped crying and he was able to take a bottle.
Yep. And that was my next question. We're right on the same page. Took a bottle, slept through the day. Gonna shuffle some more papers around. All right, I want to talk a bit about Dr. Stein's testimony. And I know that you told the prosecutor just now that you agreed that shaking's a possibility, right? That was what you said?
So shaking could be one of the traumatic events that I think Kalen had.
Okay. Right, so shaking could be included, but you're aware that this was a shaking only case, right? It was a very specific mechanism at trial.
So I'm not sure how it was presented like that. It was a mechanism, and I'm saying that in my opinion that there was a traumatic event that can include shaking.
Right, and I'm not here to push you on that in terms of trying to get you a gotcha with it. I'm more trying to talk about what the specific mechanism was alleged at trial in that fact and versus what.
My opinion, has always been, is that there are a number of different traumatic possibilities, and that shaking is one of them.
Okay, but at trial, Dr. Stein testified that it could only be shaking. Their statement?
I would have to look at the transcripts again, but just like I told Mr. Coleman, I would modify his statements. That when he said violent shaking, I said, well, I would say that there was violent forces that can include shaking.
Okay. And Dr. Stein, though, he testified that the impact that injury, right? Do you remember that testimony?
Gilbert is dismantling the prosecution's theory piece by piece. No eyewitnesses. No confession to violent shaking. The father only admitted to resuscitative shaking after the baby became unresponsive behavior that looks like panic, not guilt. She's building an alternative narrative. A man who thought his child was fine, who fed him and put him to bed, who only shook him desperately trying to revive him.
The door impact?
Mm-hmm. Or
Correct.
any impact, really. He said unless it was a motor vehicle accident or a plane crash. That's sort of extreme trauma.
Yes.
Do you agree with that statement? Dr. Stein also testified more than once that he didn't feel it was necessary for him to review the child's birth records, any sort of prior ER visits. Do you recall that testimony?
No, I don't recall.
Okay. And he had testified because he felt it wasn't necessary to make his diagnosis because if anything other than violent shaking caused those specific injuries, the retinal hemorrhages, the brain swelling, it would probably make medical history. Do you agree with that testimony?
Can you start? Can
Yeah,
you repeat
sure.
that, Ms. Colbert?
That he did not feel it was necessary to review birth records, other medical history for the child, because if it were anything else, meaning if he found any indication that there was another medical condition, a disorder that caused the findings, it would probably make medical history.
I mean, I would say as a child abuse pediatrician, I would disagree and say that I need to review his medical records
Okay.
and his birth history, review his birth history. Yes.
Did you review his birth records when you looked at the records for this case?
I reviewed the reported birth history.
Okay, you didn't look at the newborn screen?
So no, there's no newborn screen in the trial records.
Okay. They are in the clerk's records, so, or the DA's file, so, but besides that, so you're not aware then that there wasn't any sort of screening for genetic disorders, metabolic?
So they, in the critical care at Texas Children's, they ordered the organic acid testing for
I'm
it.
referring to the birth.
So unless they declined, there are mentions in the medical records that he was born at this many weeks, he got his necessary vaccines. There's nothing in the records that made me believe his parents refused the routine medical testing at birth.
That's not what I'm getting. I'm sorry, maybe we're not understanding each other. The newborn screening in Texas back in 2000, they didn't include any sort of genetic disorders or metabolic. It's not nearly as robust as it is today.
Correct. Those were introduced in 2007.
Right. So we don't know. Their statement. We don't know from the birth records if there's any sort of metabolic or genetic disorders.
From the birth records solely, correct.
And in your review of the laboratory records, the laboratory assessment from Texas Children's Hospital in St. Elizabeth, the first hospital he went to, did you see any record of them really doing a screening for all of those numerous mimics you mentioned?
Yes, they ordered the urine organic acid test.
That's it, to rule everything out?
That's what they ordered, yes.
Okay. So do you agree that they really did a robust or thorough review of all the labs?
I would say they got all the labs they needed.
I want to talk to you a little bit about Dr. Edwards' affidavit. You said you didn't look at it though, correct?
I haven't read the final version of it.
But you read an earlier draft, right?
Yes.
So are you aware that Dr. Edwards said in his opinion that a level of shaking, resuscitative shaking was what the prosecutor and you were discussing, that was described by Mr. Garner in his affidavit. That wouldn't be enough. Are you aware of that statement?
I'm not sure if it was in his previous version, but yeah.
If it's in there, if it is in there, would you agree with that statement?
I would agree with that statement.
That the level of resuscitative shaking would be enough?
Would not be enough, or would be enough for,
He said it would be enough.
I would say depending on the level of resuscitative shaking.
Well, I'll tell you this, it was in really direct opposition to what Dr. Stein testified. Are you aware that Dr. Stein testified that the level of shaking in Mr. Garner's statement would not be enough?
Am I aware that's what
Yeah.
Dr. Stein said? Yes. Yes.
Yeah, because Dr. Stein kept saying over and over that it had to be violent shaking repeatedly back and forth, what you and the prosecutor were talking about earlier, right?
I mean, if the shaking being resuscitated rose to the level of violent actions,
And you really think that's how it's described in the statements you read?
I don't think that's how it was described in the statements that was provided to the law.
I want to talk a bit about the American Academy of Pediatrics guidance back then versus now. So you and the prosecutor were talking about that the fact that it's not changed because shaken baby syndrome, or as it was known then, now abusive head trauma, that kind of slash, that it's not, or the science is the same, that it's still considered a valid diagnosis. So that's not really what the issues are here. The issues are the big changes that have happened since 2004 to now would be two areas really, right? The mechanism of injury is more vague or generalized now to include more things. And the findings are not treated as, would you agree with that characterization of the change? And I can break it down. Yeah, okay.
So I think with your first statement that we are trying to say that we are not investigators. We can't say for sure shaking happened, but that there are other traumatic forces such as being slammed, such as being swirled around that can replicate those symptoms. I think that's addressing the first part to your question. The second part to your question about symptoms being specific or non-specific, I think we need to. What symptoms are you referring to?
Sure. Well, the triad, which meaning that is what the shorthand that Mr. Coleman referred to earlier, but it's the specific findings in the eyes, the retinal hemorrhages, some subdural bleeding, whether of a hematoma nature or a hemorrhage, and usually coupled with brain swelling or some sort of encephalopathy. And then they usually have a very rapid. It's that combination of findings that were treated back in 2001, 2000, or 2000 to 2004 when this case was going on as highly specific or pathognomonic for abuse.
I mean, I've heard different versions of the triad, but I think we're trying to be better physicians and communicators to say that there are different type of retinal hemorrhages. There are that can be caused by non-external trauma, and that there are other types of retinal hemorrhages that can be caused by other medical issues.
Okay. And same for the other brain injuries. You're doing more of a thorough workup. You're considering other mimics as kind of the shorthand that could.
Can you repeat your question? Sorry, Ms. Gilbert.
No, you're fine. I'm actually just going to go right to the AAP guidance. So in 2004, when this case went to trial, the published guidance was the American Academy of Pediatrics.
So I'm not familiar with that past report, only the most recent ones.
Okay. And that's because you mentioned earlier you graduated medical school in 2019, right?
Correct.
So you're going off of, well, currently, I guess the most current guidance would be the AAP 2025 technical report is really more of a systematic review of the literature to say. But the 2020, so we'll just do a compare. We'll look at 2001 and then we'll look at 2020, okay?
Okay.
So in the 2001 American Academy of Pediatrics technical, talked about the fact that shaken baby syndrome is, and it's entitled shaken baby syndrome, the technical report. Shaken baby syndrome is no longer a diagnosis, can't talk, of exclusion. Do you agree with that statement?
Shaken baby syndrome is no longer diagnosis of exclusion. Okay, go on.
In reference to the differential diagnosis.
I mean, it should be under differential diagnosis.
That's not what they said in 2001, though. They said that the specific findings, some variation of it that we were talking about, but it's really kind of three main categories, right? Brain, eyes, brain, like neurologic brain decline or something of that nature. They said that those three findings could be treated as diagnostic or abuse, and there could be a strong presumption.
So, I mean, I would have to read the 2001 technical report, but my understanding is if you're saying three findings, and again, I've seen different versions of these three findings throughout my medical training, but if there are three findings in that are incompatible with the history that the parents have given you, you can't rule out the possibility of abusive head trauma.
Right, you can't rule out the possibility. But if that AAP 2001, and I'll move off of it in a minute because I know you don't have it in front of that guidance, a specific combination of those findings, they can be treated as pathognomonic diagnosis based on that. That you wouldn't agree with that based on your current.
So you would have to give me more details about the three findings, but there are certainly like three findings that are very highly specific for physical abuse.
But highly specific and diagnostic in and of themselves is different. Can we agree on that?
Highly specific versus diagnostic. There can be subtle differences.
They were saying in 2001 that it means shaking. They don't have any, no flexibility on the mechanism. You wouldn't agree with that, right?
Again, I think many people have different ideas what shaking is, like the other mechanisms I talked to you about, being slammed, swiveled around. Like we would consider, or I would consider that shaking because the head's going back and forth. But to the lay person, shaking means that you're picking someone up and you're going in a violent direction up and down motion. So I think that's why the term got changed from shaking to abusive head trauma. But the heart of it itself of saying that there is abusive head trauma, I think that's still valid.
It's fair to say, and I know I very much understand you and Mr. Coleman's view of the biomechanical research, so I'm not going to unpack all. It's fair to say that on the other side of the fence, those that are proponents of the fact that shaking is capable of tearing the bridging veins, of causing some sort of, axonal injury with the brain swelling, of causing retinal bleeding, they haven't been able to identify the amount of force necessary if they're going off the loading.
I mean, I would agree with that with the same reason why I was telling our judges, like, we can't do perfect studies to determine the amount of force needed to tear someone's bridging veins, to cause a subdural, to lead to retinal hemorrhages. There's no perfect model that we can produce ethically these days.
Okay. And you and Mr. Coleman were talking about a lot of clinical research earlier, right? That you feel supports the validity of these findings being linked to shaking or some mechanism, right? Of abuse.
So yes.
And that means you're looking retroactively at cases, right? That were diagnosed.
So there was also studies that they got a group of people in England and they enrolled them in the study, and then 6 months later they sent out questionnaires asking parents like, have your kids fallen? That would be prospective.
Okay, but it wasn't really validating. Like the only evidence base we really have, besides some other things I won't get into, but like confessions, the only evidence base really validating that theory that they've presented, the shaking piece, retroactive, looking at cases that were already identified under that guidance.
So retroactive in cases where kids had, I mean, I would disagree because there have been cohorts of studies where they looked at patients who fell off the bed and looked at all patients who fell off the bed that didn't have.
We're talking about shaking right now. That theory in 2001, that shaking, violent shaking back and forth, flipping the head back and forth.
The defense attorney is exposing a critical shift in medical consensus. In 2001, the American Academy of Pediatrics treated a specific pattern of injuries, retinal hemorrhages, subdural bleeding, and brain swelling as virtually diagnostic of abuse on its own. Today's physicians, trained under updated 2020-25 guidance, approach the same findings with more caution. This evolution in medical thinking is exactly what post-conviction relief claims are built on. Science that was considered settled at trial may no longer be.
Or it could cause the injuries. Your opinion is that the biomechanical research doesn't disprove it, right? It also doesn't prove it on the other side of it.
Disprove this. I mean, I would say, I would say because there's no perfect model out there in the world that you can't get a black and white yes or no.
But how about error rates? So we were talking about evidence base, and I agree. It's you can't really simplify that discussion. Error rates, though.
Okay.
That's helpful in you reevaluating how you diagnose it. Looking at error rates, looking at case reviews. Is there any known error rate for when abusive head trauma or shaken baby syndrome has been misdiagnosed?
I know of one case.
Okay, but there's no kind of regular collection of data like that you can point to.
I mean, Dr. Narong has his own study looking at traditional paperworks and looking at how many cases have been granted on appeal, and after appeal, how many have been.
That's looking at legal decisions, so that's not looking at clinical data, right?
That's the only type of research that I know about.
That answers my question, thank you. And let me just take a moment here. I want to talk about the opinions in your affidavit, and it sounds like they're more or less consistent with what you just testified to. But you say in your affidavit that you have a substantial concern for abusive head trauma without inadequate history of trauma, right?
Correct.
Okay. And we've talked about the fact you're vague on that mechanism, right? You're not willing to shave.
Shaking. I'm sorry. I'm not. Sorry. Shaking is not the only possibility. Correct.
Okay. So do you think that that's specific enough? Removing the diagnostic element of it, or actually, yeah. Do you think that's specific enough to diagnose with? I'm going to withdraw. So you're saying substantial concern pretty much all throughout your testimony and affidavit, right? Substantial. Dr. Stein, you recall he testified that he was confident to a reasonable degree of medical certainty that Kalen was. Those are pretty different, right? Substantial concern for abusive head trauma, general term regarding a general mechanism, right?
I mean,
we can, yeah.
I mean,
but it's different than.
I think again, the perception of what shaking is, it differs to people. Some people think shaking is directly up and down motion. Other people have a more global term of the shaking. Your head can swivel around, and that qualifies as shaking. Other people won't say that that's shaking. So I would.
I'm just talking about the terminology, like the level of certainty and the specificity of the mechanism in Dr. Stein's trial opinion compared to yours. Pretty different, right? There's a big gap there. Do you agree?
I mean, again, I would say that I would have modified Dr. Stein's testimony to say violent movements that can include shaking, so just up and down motion. But I would not have worded it if I were testifying back in 2004.
And would you have said, if you were testifying, that it could only be shaking? And just in general, that this could only be abuse based off what you've reviewed in this?
And so when you say this, do you mean by his?
Draw that as well. I think I just asked you the same question twice. I'm sorry about that. So we've already talked a bit about the differential diagnosis. We talked about, you've looked at the labs, you saw what you felt was a complete picture clinically of any of those mimics.
So I looked at the labs, yes.
And you felt from the lab assessments that they ruled everything out.
I think, yeah, they did it.
But we talked about earlier that the birth records don't indicate that there's any screening for any sort of genetic.
Back in 2000 when he was born, yes, there was that was not on the panel. Your panel.
And you saw on the panel, because I looked at the labs too, my experts have. You saw on the panel that they ruled out genetic metabolic disorders.
Sorry.
You saw on the panel from Texas Children's Hospital that included genetic and metabolic disorders.
Are you talking about the newborn screen, or are you talking
now I'm talking about the Texas Children's Hospital records from admission.
So they ruled out such things like metabolic disorders because they got the urine organic acid. I'm not sure about which other syndromes that you are referring to.
There are certain like factor 9, factor 12, things like that. Sort of prothrombotic conditions were included in the coagulopathy, correct? That wasn't moving away from the metabolic.
So his screens for bleeding disorders like the PT and PTT were normal. So they wouldn't need to get factor levels.
But they had at one point noted an elevated D dimer, correct?
Mm-hmm.
Okay. We can move off the labs then. So you seem pretty adamant in your affidavit that the specific pattern of retinal hemorrhages that the child had, those could only be abusive trauma?
No, not only abusive, but
okay. It didn't say that in your affidavit, but yeah, I was curious. So not only abusive trauma.
I believe in my affidavit I didn't specify abusive trauma either.
But you have said that you don't think the accidental impact that Mr. Garner described with the prothrombotic condition, which I'm not going to go back into the labs because I'm out of my depth. I need an expert for that, right? But that's even if there was some sort of condition that could a metabolic cascade, you still think that minor trauma could. But just to be clear, as a child pediatrician or child abuse pediatrician doctor, you are not saying that these specific brain and eye findings equal abuse, right?
Correct.
You have a workup you have to follow, right? And if a doctor testified that those findings, based on those findings, they could confidently rule everything out and diagnose, that's not legitimate medical expert testimony, right?
So Am I testifying only to the brain injury, or am I testifying to his brain, the history provided to me, the other images and labs?
We'll move off of that question. I think I've gotten your answer on that earlier. I want to talk a little bit more. Oh, I did have one question that I didn't ask you earlier. So infection, you also agree that that can cause brain swelling, right?
Yes.
So I saw bacterial culture was taken, but viral infections can also cause that.
Sorry, viral meningitis.
Or no, or a viral infection. Like it could be some sort of pneumonia, something.
So a kid can have viruses, yes.
So if they didn't take a viral culture, they didn't take a viral culture, correct? Did you see any indication of that?
You can't grow viruses on cultures.
Okay.
I mean, that's not practiced today.
Okay. I'm out of my depth, I think, but you think that they did rule out infection. Dr. Moore's recant, I want to talk about that a little bit, but first I want to just revisit her trial testimony. So you said more or less you agreed with her testimony when Mr. Coleman asked you about it, but I wanted to make sure you're aware her testimony besides shaking wasn't just it's consistent with shaking. She testified when the prosecutor asked her, is there anything else that could have caused that severe head trauma in the child besides shaking? She testified a severe motor vehicle accident can cause similar injuries. So she's saying here that only shaking could have caused it. And I believe she even was more specific on cross-examination.
Okay.
But I mean, the gist of that is shaking or severe motor vehicle accident. Now, do you agree with that testimony from her?
I mean, I would, like I said with Dr. Stein, I would say violent forces, not just shaking.
Yeah, they're really confining it to just one mechanism because, then the prosecutor, of course, asked, was there evidence of this crime? So we've got some steps that are being skipped here by both the state's experts in their analysis. Would you agree?
I don't know if I agree or disagree. I think that's just a statement.
Okay. And regarding Dr. Moore's recantation, what she changed her testimony on, said she would no longer testify to today, was really that testimony that it could only be violent shaking and nothing.
I mean, if that can include the car accidents and stuff like that.
Okay. But I'll tell you that the gist of it is that she said she would no longer testify based off of changes in her own scientific understanding. The reason I say that is I'm asking you as a child abuse pediatrician, if you were to testify to something today based on what your current understanding is of the medical, if that were to change in 10, 20 years as medicine and science, you would feel like Dr. Moore that you needed to fix that, correct? You made a mistake?
Or put it on the record, yes.
Yeah, which is what she did. Yeah. So you agree with that? It's the right thing to do.
Yes, to tell the truth.
I am just giving me one moment. I'm just making sure I touched on it. So you mentioned earlier, Mr. Coleman was asking you about the venous thrombosis, sinus venous thrombosis, which is you gathered what the defense. And the records that you reviewed, though, in this case, you said that you just reviewed the medical records and reviewed the CT scan.
I saw a brief slide of them like 2 hours ago.
Right, but that's because in your clinical practice, you'd rely on a radiologist or a neuroradiologist to look at scans, right?
So all doctors, when we take our medical exams, we are supposed to be able to identify some basic findings on radiographies, but ultimately we defer to our specialists when there are subtle findings.
Right, and I'm sorry, doctor, I'm aware that you have some training in your boards and things like that with radiology. Clinical practice, fair to say that you'll get scans from a patient, right, and you'll have a radiologist interpret them most often.
Yes.
And you'll talk to them about their interpretations, right?
I mean, we're encouraged to look at the images ourselves and
like an imaging report or something like that. Okay. And so then on that basis, you provide your medical. That's standard. That's so if our expert, Dr. Glasnick, who has a background as a clinician in pediatrics, if he had a neuroradiologist, Dr. Baslow, look at the DICOM files of the brain, is that not standard clinical practice for him to rely on his interpretation?
I mean, I would still ask my neuroradiologist to, either on the scans with an arrow or to show me where where this interest of study is. To my knowledge, Kalen only had a CT scan, and that's not the best mode of imaging to detect thrombosis.
That's interesting you say that. Yeah.
You know, I wish, you know.
Yeah.
I mean, the gold standard nowadays is MRI, but
Right. And I think I believe I've read some literature on that. So there was indication, though, at least according to our, and I'm not going to get into all the medical because we've seen how that goes so far for me, but there was, and so the next step, as you said, would have been to get a more comprehensive imaging done, right? Like an MRI or something like that, or some sort of, I think it's called venography to detect the thrombosis or see if there's any clotting in the veins. Okay. And clearly that wasn't done in this case, right? Because the original radiologist didn't note any blood nor. But is it possible?
I mean, you know, kind of looking at the full file, if Kalen had a disease that
This exchange reveals a devastating pattern in shaken baby cases. Experts who once testified with absolute certainty now admit science has moved on. Dr. Moore's recantation isn't about admitting error, it's about acknowledging that medical understanding evolves. The defense is building toward a constitutional argument. If the science that convicted Garner no longer holds, does due process require a new trial?
made him, you know, have thrombosis, I would have expected, you know, thrombosis to reoccur after he had been discharged from the hospital.
Okay, but I'm just talking about what they're doing in the workup. And I will have our other expert address what can happen in clinical presentation with thrombosis long term. But if there's indication in the charts, there was some evidence of a right occipital bleed in scans. They just, for whatever reason, radiologists left it out, but some doctors noted that they noted it because, as you said, they look at. So if you follow all that, would that be indicative that maybe you needed to go and get an MRI or do venography to rule out thrombosis?
It depends on the standard of medicine back then in 2000.
Okay, but we're talking about today's standards.
So today we would have CT'd his abdomen, we would have done an MRI of his neck and head. That is today's standards.
And if you saw indication in this, what might be thrombosis, like sinus thrombosis, would you follow up with an MRI to rule it out?
The thrombus would have been identified on the MRI.
Yeah, no, you had just said CT earlier, if I had misheard you, but.
So today's standards, everybody will get an MRI.
It's all MRI, no CT.
You get both.
Okay. That answers my question on that. Just give me one moment. I'm just making sure we cover. I think we're good. Thank you very much, doctor.
Yes, Gilbert.
Just a handful of follow-up questions, if I may. Dr. Ms. Gilbert mentioned the defendant's trial testimony. Is it fair to say that the jury that heard his trial testimony could have completely rejected his version or his testimony and found it to be? Ms. Gilbert talked about the metabolic or genetic or lack thereof of the metabolic or genetic screening done on Kalen at Texas Children's. I mean, the urine organic acid test, is it your testimony that it would be sufficient to pick up such, if there was an abnormality in that respect?
Yes.
And there was one done. As far as the level of resuscitative shaking or the level of shaking at all, I mean, we're starting with the presupposition that what the defendant said is true, right?
Correct.
And there's no basis for that, right?
We are relying on his testimony.
Yeah, of the testimony or the representation of a convicted felon, of someone who, in your training and experience in determining or diagnosing abusive head trauma in infants, would have a motivation to minimize what happened to that child. Right now, there was mention of mimics, as it has been characterized, mimics like either a bleeding disorder or some metabolic or genetic disorder, even infection. There's been mention of that. Genetic, metabolic, infection, those are all different from a sinus venous thrombosis. You understand that's all the testimony we have in this particular case. as to an alternative that would mimic the effects of shaken baby syndrome. That's the only testimony that we've had in this case, correct?
I mean, I wasn't here yesterday, so
That's a fair point.
I don't know if there's other.
That's a fair point. If I represent to you that there was only testimony with regard to sinus venous thrombosis, you have no reason to disagree with that, would you?
No reason to disagree.
You talked about the period Kalen was discharged from the hospital. I don't know if it's entirely clear to the court that Kalen was in fact discharged from the hospital and spent some time in foster care before he died. Is that your understanding?
I did not know that.
Defense counsel or counsel for the applicant mentioned the discharge, or there was at least a mention of discharge.
Sorry, do you mean discharge from the Texas Children's or discharge from the birth hospital?
Discharge from the Texas Children's is what I'm referring to.
Oh, yes, he was in foster care.
Yes, in foster care for a number of months, correct?
Yes,
10 or so months.
until at least July or August. Could have been past that too.
And the reason why I mention that is because you talked about detecting, there's testimony about the ability to detect the thrombosis. During that period that Kalen was discharged, would that have been an opportunity for either the condition of thrombosis to worsen or to be become more prominent?
There's that possibility.
Any indication that was the case here? And last question, there was mention about Dr. Moore coming forward if there had been a change in the science. Again, we talked about, right? Is it your testimony that there's a change in the science or a change in the theory of a mechanism that could lead to that particular injury?
The latter, the theory.
Okay.
Anything else, Ms. Gilbert?
Just briefly, Your Honor. Doctor, you'd agree that the mechanism, the process of diagnosing a condition, that is a change in medical understanding.
The process.
Let
I
me
would say, yeah, can you rephrase it?
Yeah. You would agree that an evolution in the understanding of what conditions can mimic or diagnosis, like shaken baby syndrome or abusive head trauma, that's a change in medical understanding.
I sorry, I forgot the first half of your statement. Can you repeat that again?
You'd agree that if there's been changed guidelines, which the AAP, you'd agree that multiple AAP guidance papers have come out since 2001, right?
Correct.
And those papers are published because they're guidance on how to evaluate suspected abusive head trauma, right?
Yes, I mean that's why today's standards did MRI everyone,
And
including the neck.
so that's evolution or change in the medical understanding, correct? Medical knowledge.
There's additional medical knowledge, yes.
Yeah, I can tell I'm not using terms you like, but
Yes.
it's an involvement in the understanding of how these cases are approached, right?
Correct.
Okay. For instance, 2020 AAP, that thorough workup, evaluating for all possible, ruling out all possible diagnoses, right?
Yes.
That list you make in your differential diagnosis.
Right.
And I know you say you're not familiar with the 2001 AAP, but that's what was the standard when Mr. Garner was. And that said, it's a diagnosis of exclusion, shaken baby syndrome. If that is what it said.
So if you
Or
say
sorry,
diagnosis
I
of
withdrawn. I misspoke. Sorry. The 2001 statement, if that said it is no longer a diagnosis of exclusion,
okay.
that the findings, which I believe at that time it was retinal hemorrhage, subdural or subarachnoid hemorrhage, and brain swelling. Those findings are virtually diagnostic. That was the guidance. So
I mean, I would change some of that wording to include diffuse bilateral multi-layer hemorrhages, subdural hemorrhages. If you're asking me if there's been evolving workup, yes, there's been evolving workup.
And those findings, however the current clinical understanding phrases them now, those are treated as suspicious for abuse now, correct?
Yes.
They are not treated as conclusive evidence. Thank you. No further questions.
And
Anything
nothing
else?
further for Dr. Your Honor, may he step down.
Any objection to that? To Dr. Hugh being,
Oh, no, Your Honor. Thank you. Sorry.
thank you, doctor, you're excused.
Thank you so much.
All right, let's take just a 10-minute mid-afternoon break before the next witness. It's 2:45 to 3. We'll try to get started about 5 till or so. All right, court will be in recess. Third. Mr. Coleman, you may call your next witness.
This time the state called Dr. Daniel Lindberg.
Dr. Lindbergh. How are you, sir?
Thanks.
Good afternoon. And if you'll just make sure that green light's on the microphone on the left.
Thank you, Your Honor. Would you please state your full name for the court reporter?
Daniel Lindbergh, the last name is spelled Lindberg.
And Dr. Lindberg, how are you employed, sir?
I'm a professor of emergency medicine and pediatrics at the University of Colorado and the Kemp Center for the Prevention and Treatment of Child Abuse and Neglect.
And your training and background that has led you to hold that position, could you briefly summarize it for the court, please?
Did my undergraduate degree in biochemistry at Harvard University. I went to med school at the University of Chicago Pritzker School of Medicine. I did a residency in emergency medicine at the University of Cincinnati. I did a fellowship in child abuse pediatrics at Cincinnati Children's Hospital Medical Center. And I've been practicing in emergency medicine and child abuse pediatrics since then. I finished my fellowship in 2006.
And you are board certified, correct?
I'm board certified in emergency medicine.
And have you been an instructor in the past at an instructor of medicine at Harvard?
Yes, I was an instructor and then an assistant professor of emergency medicine at Harvard University Medical School.
And we won't go into all of the details, but you received numerous awards throughout your career. Is that fair to say?
Correct.
And you've served on various committees, correct?
Yes, sir.
What I do want to mention is some particular research that you've done or types of research that you've done, and why is it noteworthy? Could you expound on that, please?
About half of my job is to see patients in emergency departments and as a consultant for the Kemp Center Child Protection Team. The other half of my job is as a clinical researcher. My research has been funded by the NIH, the Agency for Healthcare Research and Quality, the Department of Defense, the state of Colorado, and other various foundations. And that's important because there's different kinds of research. There's reading papers that other people write, and then there's actually conducting the research studies. And I think it's important to distinguish those two.
Sure. And during the testimony of Dr. Yu, the name of Dr. Sandeep Narang came up, and Dr. Yu testified about how respected or highly regarded he thinks of him. What, if any, opinion do you have about Dr. Sandeep Narang?
I've worked with Dr. Narang on a couple different studies, most importantly, a survey of clinicians who care for children who may have experienced abusive head trauma. And I have found him to be a very responsible and dedicated researcher. I have a lot of respect for his results.
And the two of you worked on some publications in the past. And I mentioned Dr. Narang for this one reason in your resume, is the fact that as respected as he is, and I know that you're a humble person, I'll get the impression that you like to toot your own horn, but as respected as he is, you list in your resume that you actually mentored him between 2014 and 2019, right?
I would consider it peer mentorship. He certainly taught me things, but I had been doing research for a few more years than him, and so I helped him, especially with that survey project.
You also mentioned in your resume that you've published peer review articles or papers in journals to the tune of about 111. Is that correct?
That's correct.
You testified in court on few or on many occasions.
I haven't kept count, but I suspect since my fellowship, I've testified more than 24 times.
And have you testified as an expert? So much for your background. Let's talk about your work in this particular case, where you asked to review certain records and a case file as it relates to the death of a 2-month-old. He was 2 months old when he was injured. I think about 11-month-old when he ultimately expired. The child's name is Kalen Garner. Did you review those records?
I did, sir.
And briefly for the court, what did those records entail?
I reviewed Kalen Garner's medical records at the time of his initial hospitalization and subsequent stay in the intensive care unit and the hospital. I reviewed initial case findings and legal arguments. I reviewed arguments made in the request for the writ of habeas corpus. I reviewed some pictures, laboratory results. That may not be a complete list.
included in that information, was there a reference or references to the state or the circumstances surrounding how Kalen Garner was discovered back in February 2000?
Yes.
What's your understanding after reviewing those records of how that all happened?
My understanding is that Kalen Garner was reported to be in his normal state of health uh, at the time that his mother left for work between 5 and 6 in the morning on the 25th of February, and that between 2 and 3 o'clock, a CPS worker came to his house for an unannounced visit, at which time it was noted by his father and the caseworker that he was obviously very ill. He was then taken to an emergency department.
Let me
Where-
jump in there real quick, Dr. Lindbergh. His father being Luther Garner, the defendant in this case,
That's my understanding.
and Luther Garner being sole caregiver for Kalen after the mother left for work that day.
That's my understanding, yes.
Please continue.
So he was taken to an emergency department where the clinicians there thought that he was having seizures and found him to be critically ill. He was given medicine to treat seizures. He underwent diagnostic testing, most important of which was probably the CAT scan of his head, which showed severe brain injury. And then he was taken to Texas Children's Hospital.
Let's back up about to the delay in providing. Are we talking about a matter of minutes, or are we talking a matter of hours? As your understanding from reviewing the file.
So my understanding is that the time that Kalen started to show symptoms changed with different stories, and that initially, when the CPS worker presented and when the history was given to the initial emergency department, the story was that Kalen had just started to make some funny noises while he was sleeping, or he was breathing funny. And that it seems that the initial story was that he was taken for care soon after he began to have symptoms. But that subsequently, later versions of the story said that he became ill around 10 a.m. when Jerry Springer was on television. And the thought was to wait until his mother got home from work, or there were other things that were done to try and get him back to normal. And so it's unclear whether the delay was several hours or several minutes. But I think by the time the initial case was tried, the accepted story was that it had been several hours.
And in your training experience, diagnosing abusive head trauma cases in infants, is a delay. What is a delay in seeking medical attention potentially indicative of?
So the research suggests that a delay in seeking care that is not reasonable is a strong indication for
Expert witnesses in post-conviction proceedings face unusual scrutiny. Their credentials aren't just for show, they're ammunition. Dr. Lindbergh's 111 peer-reviewed publications and NIH funding matter because habeas courts must decide whether new science has emerged since the original 2004 trial. The prosecution is building his authority early, knowing the defense will attack every study he hasn't personally conducted.
abuse. Now, there's some complexity, and I hope you forgive me for going into some of the details on this. Most people have had a child who's had maybe an injury or even a broken bone, and it's very common for a child to break a bone in the evening. They say they fall off their bike or have a minor injury, and parents to go, oh, let's give them some Tylenol, see how they're doing in the morning. My boss even sent his child to school with a broken bone. This is a pediatrician, and later ended up finding out that the child's sore foot was actually a broken bone. That's not something that we get very excited about. It's difficult to communicate these sorts of details to people who don't practice child abuse pediatrics all the time. But when a child has an obvious injury, like they're not breathing correctly or they're seizing, or the other clear example is if they've got a gigantic burn and someone says, well, I wanted to wait till someone else got home from work, or I wanted to wait for something else. That, I think, both from the research and as a parent and common sense, it suggests that someone's motivations are something different than My child is ill and I want to get them help as soon as I possibly can.
Fair point. What about exhibiting symptoms of eyes rolling in the back of their head?
Yes, I mean, I think things that could be seizures and breathing differently are the classic example of something where most reasonable parents would seek help because they know that the child is very ill. And when you don't do that, that has been strongly associated both in common sense and in research with other findings of abuse.
Very good. And in fact, the CPS caseworker that showed up unannounced and discovered Kalen in the state immediately took Kalen to the emergency room. Is that your understanding?
That's my understanding from review of the records, that there was some discussion between Luther and Miss Ruby, and Miss Ruby said, we have to go right now.
Let's talk about what was discovered once at the hospital. The initial CT scan, what did it show?
The CT scan showed devastating brain injury throughout most of Kalen's brain. This is referred to in multiple different ways. They'll talk about hypodensity, they'll talk about swelling, they'll talk about anoxia, all sorts of medical terms. But what this means is that most of Kalen's brain was severely injured and not doing well.
What is that indicative of in your training experience?
It certainly, you wouldn't look at a CAT scan and make a diagnosis without the rest of the information. There are several things that can cause this sort of swelling and brain injury. If it was just in one section of the brain, you might think about a stroke. Certainly, that's much less common in a 2.5-month-old. It's older people like me start to be at risk for that sort of thing. Drowning, strangulation, or significant trauma, including the possibility of shaking.
Okay. Eventually, from your reading of the record or the documents, a final story emerged of accidentally hitting Kalen's head on a door frame. What is your, if taken true, your thoughts on that?
That story was very concerning to me for several reasons. The first is, I wouldn't expect that sort of injury to cause the findings that we see on the CAT scan. Children who have a single impact against a door frame, first of all, it's usually not a lot of force if that happens. Second of all, it's not a common story I see when I'm working in the emergency department of children having to come in because while they're being carried, they strike their head against the door frame. But also, it wasn't offered to the people who were caring for Kalen at the time.
What do you mean?
I mean, that story was not given to the emergency clinicians when Kalen got to the emergency department. Throughout the entire chart, for days and days and days, the story is this child was brought to the hospital because he was breathing funny. No one says, oh, also there was trauma. And in my experience, when someone is concerned that their child has experienced trauma, the first words out of their mouth are, help, my child has experienced trauma, or help, this happened to my child and I'm concerned they're hurt. Not, help, my child's breathing funny, and then later, oh, right, they hit their head. To me, both in common sense as a clinician and in the research, that sort of change in history is very suggestive of abuse.
Okay, so this story about the door frame was never given to the medical professionals. Who was that story ultimately given to?
My understanding from review of the records is that the story was given to the detective approximately 1 week after Kalen went to the hospital.
And with all of these circumstances, this allegation or assertion that the baby hit his head on a door frame, the lack of providing that information initially to the medical professionals, the delay in seeking medical treatment, and the ultimately providing that information to law enforcement only, would all that consist of or comprise of the patient history?
Not to split hairs with you, sir, but it's the history, the laboratory findings, the physical examination findings, all those things are taken together, yes.
And we'll get to those things, but for now, at least for now, that's part of the patient history, right?
That's right.
Okay. Was there any signs, at least in your review of the record, of accidental crush injury, sepsis, leukemia, or any other medical illnesses?
So I considered all those things because each of those diagnoses can cause retinal hemorrhages, which is something that was found in Kalen and is indicative of severe brain trauma. But it can also be caused by bleeding disorders.
The evolving history problem, where a defendant's account changes over time, is a classic abuse indicator that courts treat as behavioral evidence. Dr. Lindberg walks a careful line here, distinguishing between reasonable parental delays, the broken foot sent to school, and unreasonable ones, seizures during Jerry Springer. The comparison matters because post-conviction courts must assess whether the original jury heard scientifically sound distinctions or inflammatory character attacks.
Ischemia, sepsis, or a crush injury. The most common reports are heavy television sets landing on children's heads, and I didn't see signs of that in the laboratory evaluation, physical examination of the history.
And differential diagnosis, we talked about that with previous witnesses. We're not going to spend a lot of time on that at this juncture, but by ruling out those other causes or other possibilities, is that consistent with the differential diagnosis? So now I'd like to kind of, and you touched on this, you kind of got there a little earlier than I was intending, but the findings in total, before you arrived at your conclusion, what were in total the things that you considered?
I considered several possibilities for what may have accounted for Kalen's presentation. I read the case. I knew what this was about. Obviously, I considered abusive head trauma, and there were several findings that we discussed that are very consistent or indicative of abusive head trauma. I considered the possibility of accidental head trauma, and certainly the most important one would be the strike against the door frame that was given about 8 days after Kalen presented to the hospital. And I think we talked about why I don't find that plausible. I also considered the possibility that an injury could have happened that no one knew, that was purely by accident. And that's super unlikely in a 2.5, 3-month-old child because they're not able to move around and cause their own injury. In a child that young, I consider the possibility of a birth injury causing this sort of thing. And birth injuries can cause small subdural hematomas, but these do not cause sudden neurologic collapse or the findings that we see on the CAT scan in Kalen. I consider the possibility of birth injury causing retinal hemorrhages, but those almost always resolve by 1 month of life. And these were severe retinal hemorrhages that existed into the 3rd month of life. I considered the possibility of rare medical problems such as a bleeding disorder. But again, this was not really a brain injury that was primarily a bleeding problem. This was an injury to the brain itself. And Kalen didn't have signs of bleeding problems. He lived another 9 months with no problems with bleeding. He had had a circumcision, no problems with bleeding. He underwent 3 surgeries in the hospital where if he had a bleeding problem, we would have expected that to show up, and we didn't see that. And his blood tests for bleeding disorders didn't really seem out of range for a child who had experienced severe brain injury. I considered the possibility of infection, but we didn't see signs of that would explain the sort of thing. The main thing would be meningitis. And meningitis is not something that goes from normal at 5 a.m. to almost going to die at 2:30 in the afternoon. Those are the main things I consider.
You mentioned something that makes me want to skip ahead in my outline is you mentioned there was an injury to the brain itself. And it makes me recall what you put in your affidavit about the example used by Dr. Stein, the example of the tomato in the container. If you could elaborate on that for the judge.
Yeah, I read Dr. Stein's testimony in the initial trial very closely because he was a clinician who cared for Kalen, and he was very strong in suggesting that this was abuse and shaking. And he used the example of a tomato being shaken in a jar. And there are some brain injuries that consist of bleeding around the brain, between the brain and the skull. And sometimes that blood can build up enough pressure to push on the brain and cause damage to the brain, either by pushing on it directly or by pushing it through one of the holes in the skull, something we call herniation. This was not that case. The primary injury to the brain was irrespective of bleeding around the brain. There may have been a little blood between the brain and the skull. Maybe there wasn't. It's not clear from my review of the CAT scans. But the main injury was to the brain itself, which is entirely consistent with shaking.
With that being said, is it fair to say that the bleeding around the brain would have been secondary to the injury?
Sorry if I wasn't clear. I'm not sure there was bleeding around the brain. Let's assume there was. I can't tell if that happened from the same mechanism that caused the direct injury to the brain parenchyma, the brain tissue itself. I couldn't say if a small amount of bleeding could have happened after the brain was injured. What I can say is that it's not that bleeding happened and that caused all the injury to the brain itself. Something else injured that brain.
I see. Let me get back to my outline here. We were talking about the medical findings. What I was really trying to get at is the sum or summation of those medical findings. The subdural hemorrhaging, and I know you want to spit some hairs on that, and I'll allow you to. But for now, let me refer to it as subdural hemorrhaging, the retinal hemorrhaging. There was the patient history and how it changed, and then there was the absence or ruling out through your differential diagnosis these other potential. Is that a fair kind of summation of or recap of everything that was
The
going on?
most important, it leaves out the most important thing, which is the injury to the brain itself.
Okay.
Now, bleeding around the brain, which is called a subdural hematoma, can be part of a brain injury, but in this case, it was the damage to the tissue itself, not the bleeding around it, that was the most important injury for Kalen. That is what led to his neurologic devastation and ultimately when his breathing tube was displaced to his death.
And all of those things, and the evidence of all of those things, you don't have any reason to believe, do you, as you sit here today, that all of those things were not presented to the jury that ultimately made the determination as to guilt or innocence?
No, sir. My understanding is that all those things were presented.
I want to talk to you now about the triad, or what's been referred to as the triad. What's your understanding of that, and what are your feelings on how that's been characterized?
Triad is not something that we use to teach residents or fellows how to recognize abusive head trauma. It is not something that is used in medical practice. I've encountered the triad only in courtrooms, and my understanding is it is a way to oversimplify how clinicians diagnose abusive head trauma. I want to make something clear. Doctors understand the importance of a diagnosis of abusive head trauma. We understand that for the child, for the family, for the person who was caring for the child at the time, I can't think of a diagnosis that I make that has more important outcomes. And I tell people they have cancer and heart attacks and stroke and that they're going to die in a month. And none of those things are as important as a diagnosis of something that really is saying somebody hurt this child. And no one approaches that kind of diagnosis with anything less than the most serious intentionality and care that you would ever do. The idea that you would use a checklist to make this diagnosis is borderline offensive to people who practice medicine because they understand what it means.
And you beat me to my next question, this notion of a checklist that if you see subdural hematoma, if you see retinal hemorrhaging, and there's altered mental state, then that's it. You stop there. You've ticked all the boxes. Let's chalk it up to shaken baby syndrome.
I personally have seen children with subdural hematomas, retinal hemorrhages, and altered mental status where I didn't even consider the possibility of shaken baby syndrome because these children presented with serious trauma, such as car crashes, with ejection, or with rollover of the vehicle. And no one said, well, they've got these 3 things on the checklist. It must be shaken baby syndrome because that would be absurd.
Okay. Shortfall studies. The judge has already given me some guardrails on this. I think you and I talked about this. We're not going to spend a lot of time on it. The only reason why I think it's relevant is because the shortfall studies are indicative of the notion or the theory that minor injury can cause a secondary result that ultimately leads to the death that mimics a shaken baby syndrome diagnosis or abusive head trauma diagnosis in an infant. Please, what are your thoughts briefly for the judge on that?
Yeah, I think you summarized it well, but if you'll permit me, at the risk of being redundant, the ultimate question that scientists are trying to answer is because frequently in a child who presents
Differential diagnosis is how doctors eliminate possibilities until only the most likely cause remains. Here, Dr. Lindberg systematically rules out birth injury, bleeding disorders, infection, and accidental trauma, each with specific medical reasoning. This method mirrors how courts evaluate evidence, pie-chew the impossible, and what remains, however improbable, must be considered.
with a devastating brain injury, someone will say, oh, well, they had this minor trauma. And certainly this minor trauma could lead to this devastating brain injury. And so if you're going to do science on that, you have to define your terms. What counts as a minor injury? How minor are we talking about? How do we define this? And children who fall from standing or off furniture or off a countertop or from hospital beds are so common that it presents the researcher with an opportunity to say, okay, this is how I define my group. What sorts of injuries do we see from this? And then we try and argue from other minor injuries, like I hit my head on the doorframe, right? We don't have as many kids where that gets witnessed, and so we can't do science on that group. But the shortfall injury, most of those papers have asked, can you get a subdural hematoma from a shortfall? And I think it's fair to say the short answer is yes. The long answer is yes, but really, it's really uncommon. But we're not talking about a case of a child who experienced a subdural hematoma. We're talking about a child who may have had a subdural hematoma, but who had devastating injury to the tissue of the brain itself. And that does not happen from shortfalls or minor injuries.
And part of this assertion includes the notion that it can cause a rebleed, or in the case of the testimony that was provided yesterday by Dr. John Galaznik, the fact that it could cause an epidural hematoma that leads to an intracranial venous thrombosis, which mimics the shaken baby syndrome or abusive head trauma in infants. What are your thoughts on that?
I have so many problems with that idea, and I will try to be brief on this. Certainly, children who have subdural hematomas that we know that they're from, where I come from in Colorado, these are skiers or football players or kids in car crashes. And we certainly diagnose subdural hematomas in these kids. And not uncommonly, when they come back for care, we'll repeat their scans. And we'll see sometimes that there's brighter blood on the CAT scan, or the pocket of blood has grown in size. And people reasonably assume, okay, there's been some rebleeding into the subdural hematoma. So if the question is, can you get rebleeding into a subdural hematoma? The unequivocal answer is yes. But the assumption then that causes something that looks like abusive head trauma is completely wrong. So in those children where we know that they have subdural hematomas from football accidents or skiing, we don't send them home with helmets. We don't expect a few of them to come back neurologically devastated because they had bleeding into these subdural hematomas, which we've already said is really common. And trust me, we would know if that happened. At the University of Colorado, if we knew that a child had a subdural and we sent them home and they came back to Swedish Hospital or Lutheran or University of Massachusetts, we would get a bad Yelp review. Someone would tell us that this child had a devastating change in what happened to them after their subdural hematoma. We do not see this. And if it happened, we would see this. But most importantly, going back to Kalen, Kalen's injury to his brain was not because of pressure from blood between.
The triad, subdural hematoma, retinal hemorrhage, altered mental status, has become controversial in shaken baby cases. Dr. Lindberg's testimony reveals a critical tension. What lawyers call a diagnostic checklist, doctors call an oversimplification. The same three findings in a car crash victim prompt completely different conclusions than in an infant with no witness trauma. Context, not checkboxes, drives medical judgment.
In his skull and his brain. His injury to the brain was a primary thing that happened to him when he experienced trauma, including the possibility of shaking.
So is it more apt or more appropriate, in your opinion, let me ask this before I ask that question. So is it your testimony that the science as it relates to the diagnosis of and the treatment of shaken baby syndrome or abusive head trauma in the infants, that's remained the same? Is that your testimony?
To be clear, in the last 20 years, there have been advances in the science related to shaken baby syndrome. We have seen the mortality, the number of children who die after being diagnosed with shaken baby syndrome, cut in half. And that may be because we're doing a better job caring for those children. It may be because we're doing a better job of recognizing children who have more minor brain injuries. We've developed fast MRI to avoid exposure to ionizing radiation. We've developed better ways of recognizing seizures and treating them. We have made important advances. Does our understanding of what it takes to cause findings associated with shaken baby syndrome, has that changed significantly in the last 20 years? I can't think of a way that's important to this case.
So with that being said, the understanding of shaken baby syndrome or abusive head trauma has not changed, in your opinion. This reference of new, quote unquote, new science, is it more apt or more appropriate maybe to refer to it as a new theory of a mechanism or a new theory of or hypothesis of the manner in which these injuries may be caused?
I've certainly seen, I've read about cases where people invoke new hypotheses about how something occurred and suggest that it is new science. I believe that there are scientific advances related to shaken baby syndrome, but I don't believe that I read anything in this case that was real new science that made us understand that this could have happened in a way other than significant trauma that we weren't told about.
Let's talk about what was available back in 2000. The science was available back in 2000 to detect a cerebral thrombosis. Is that fair to say?
The concept of cerebral sinus thrombosis has been around for decades, and certainly the idea that that may have led to findings that could be confused with shaken baby syndrome has been around for decades, certainly 20 years. Since the original trial, new science has come up about cerebral sinus thrombosis, including a paper that I wrote and others that are better papers that suggest that it is unlikely to cause the findings that we see in this case or things that could be confused for shaken baby syndrome. In fact, the science really suggests that clots in the veins in the brain, or cerebral sinus thrombosis, are very likely to be an after effect, a result of trauma to the brain, not of a cause of something that looks like trauma to the brain.
And my last question on this notion of shortfall, or in other words, minor trauma that leads to a symptom or a cause that mimics shaken baby. And that question would be the studies that relate to shortfalls. If you had to divide them up, say I have two buckets, the bucket with case studies and the bucket with clinical research studies, oversimplifying the research studies, there's some nuance to that. But for the sake of my question, two differences, two different buckets, case studies versus clinical research, either prospective or respective, prospective or retrospective. What bucket would you put the majority of these case studies in as it relates to shaken baby or shortfalls?
So if you get training in clinical research, on day one, you'll get a list of study methods, and they'll generally rank them as better or worse. That's a little bit like ranking the tools in your toolbox as better or worse. There's no better tool or worse tool. It depends on the job you're trying to do. Case studies can be useful for certain things. Most importantly, a case study is useful to determine.
See that?
No.
Everywhere. I'm sorry. A bug literally just dive bombed to my face.
Oh.
And I didn't want y'all to think that I was having some.
I tried to kill it a second ago.
No, it went straight.
A
Sorry.
case study does have important uses. Sometimes it's just educational. Oh my gosh, we haven't seen this disease in 20 years. We saw this great, interesting case. This is a great way for students who haven't seen this before to learn about it. Early in the course of a disease, COVID toes, COVID thromboses. The first time someone saw that, writing up that one case and saying, dear clinicians, maybe you should think about this in the future, super important. In our field of child abuse pediatrics, a well-designed case study can show you. So for example, probably the best one is a videotape. A family was watching a movie, and I think it was a 3-year-old or a 5-year-old saw their infant sibling on a mat and said, I want to roll my brother or sister over. And the family said, okay. And the 3-year-old rolled up, and the kid's arm got caught behind him, and you could actually hear a snap. And the child started crying, and they took the child to the hospital, and the child had a broken bone. If you have the question, is it possible for a 3-year-old to cause a broken humerus in their 3-month-old brother? That question has now been answered definitively. It is possible. But it doesn't tell you how often it happens, how important it happens. And one problem with case studies is that you really have to trust the authors to include all the relevant information. And if someone doesn't know what they're doing, or if they're committing scientific misconduct, they can leave out really important findings in their case studies, which really affects how you interpret those case studies. And you have to rely on being able to read those cases. Now, other scientific methods would include a prospective study where we define what counts as a minor injury, what's a shortfall, what injuries are we looking for, what testing are we going to do. These are often called hypothesis-driven studies, or there's more robust methods. So in the end, a case study is probably still most commonly the least useful thing, but there are some things that can be very useful.
Very good. You mentioned being more robust, and as part of that robustness, does it include peer reviewing?
When you publish your results, it's very important that they be peer reviewed and that your methods include enough information that if someone wanted to do the same experiment again, they could do that.
And what about the opportunity for practitioners to comment on that study?
Yes, there's not a simple yes, no, this is right, this is wrong. Nothing's proven in science. Things are only disproven in science. So the conversation that goes on after a study is published is part of deciding how important that study is.
There was testimony yesterday by Dr. John Galesnik that there are, in his estimation, hundreds of case studies out there on abusive head trauma. Is that something that you would agree with or disagree with?
There are certainly hundreds of research publications related to abusive head trauma.
Those studies, they're not all created equally, are they?
That's correct.
And again, for the reason that you just testified to about whether or not it's peer reviewed, if it's robust enough, if there is an opportunity for a practitioner to comment on it. I guess what I'm getting at, my ultimate question is, if someone were inclined to, and I'm not saying that that's the case in this particular case, but if someone were inclined to, out of those hundreds of studies, they could very well cherry pick certain studies that set forth a certain opinion that they wish to set forth.
Yes, I find this one of the most difficult things of dealing with science in the courtroom. Most people in courtrooms have lives and jobs that are not to read all the literature in child abuse pediatrics. And so to ask, how do we decide? Is it Dr. Lindbergh? Is it Dr. Galesnik? We don't want to say who's got more gray hair, who's got a better outfit, who went to the better school. That's not a reliable way. But you can't read all the methods for every single paper to decide. And so I try my best to communicate what are some problems with other people's studies, what are the studies that have been accepted by the most prestigious organizations, people who do their best, people who actually care for children, the people who actually do the work every day, compared to someone who might the only reason they're testifying is because, or the only reason they're talking about a study is because, they spend most of their time in the courtroom.
Yeah. Let's get back to your conclusions or the determinations that you made in this particular case. Your conclusion, and I have it in quotes here, is there was severe abusive head trauma caused to Kalen Garner in this case. Is that a fair assessment of your conclusion?
Yes, that's still my conclusion today.
Why do you characterize it as, this may be redundant, but you characterize it as severe? I think you've already covered it and the reasons why. I don't know I have to even spend any time on that. Let me move on. But what I do want to talk about is during your review, you looked at and you mentioned Dr. Stein's information, his determinations, particularly the tomato in the container example. But did you also look at Dr. Patricia Moore's report and the determinations as well?
I did review Dr. Moore's testimony.
Let's take those individually, please. Dr. Stein concluded that there was violent shaking of the body with interior and posterior movement of the head, either multiple or repeated times, causing the brain to shear the neurons and to swell and bleed behind the eyes. Do you agree with that based on your entire review of the file in its entirety?
I'm not sure I would have been as definitive about whether the shaking was anterior or posterior. And I think there are other forms of violence that could have caused this other than shaking. Being thrown down, thrown violently against a soft surface, I suppose it's possible. I certainly think that shaking is the most likely mechanism that could have caused this. And I agree almost completely with Dr. Stein's conclusions. But, in the last 20 years, the changing of the name from shaken baby syndrome to abusive head trauma, does demonstrate the consensus that while we agree this is violence, while we agree this is trauma, we as clinicians don't spend as much time figuring out if it's shaking per se or slamming or throwing.
I understand. And if you recall, do you remember whether or not Dr. Stein was a pediatrician with the Texas Children's Hospital here in Texas?
My understanding is that he was a pediatric intensivist. He worked in the pediatric intensive care unit at Texas Children's, if memory serves.
Any reason to disagree with my representation that he had 25 plus years in the field at the time? In your opinion, in your professional opinion, who is best suited to opine about the diagnosing and treating shaken baby syndrome and or abusive head trauma in infants? A clinical practitioner who diagnoses and treats that on a regular basis, or some biomechanical engineer or a law professor?
I don't think a biomedical engineer is qualified to make this diagnosis, but I don't want to get trapped into saying that I agree with everything someone says because they're an experienced clinician. I will note that in his medical records, every emergency physician, every neurosurgeon, every neurologist, every emergency physician, every general surgeon, every pediatric intensive care unit, doctor, and every radiologist who reviewed the case concluded that the child had experienced abusive head trauma or shaken baby syndrome.
I'd like to shift gears to Dr. Moore's, both her written determinations in the file and also her testimony trial. She concluded that there was some type of direct force to the head, whether it be shaking through a shaking mechanism or not, and that there was some type of acceleration injury to cause the problems in the brain and the eyes. Do you agree or disagree with that assertion?
I do, with the understanding that acceleration injury is an extremely broad term.
And during your review of the case file materials, Dr. Moore, in being questioned at trial, answered this question in this way.
Dr. Lindberg just exposed a critical vulnerability in how courts handle scientific evidence. The cherry-picking problem lets opposing experts cite hundreds of studies without context, forcing judges to become amateur scientists. This is why Doebert hearings exist, to filter reliable science from junk before it reaches the jury. The challenge? Most judges lack the training to spot methodological flaws in complex medical research.
When asked if the injuries were consistent with a closed head trauma due to shaking, she answered yes. Do you have any reason to, based on your review of the file, to disagree with her answer there?
No, the injuries were consistent with that sort of injury.
During the trial, she also, in response to this question, stated in the affirmative. When asked if it would have had an immediate effect, her answer was yes. What is your take on her assessment?
I agree. The amount of damage done to this brain tissue would have been something that a layperson would have appreciated within minutes.
And you've provided the district attorney's office with an affidavit. And is that affidavit essentially a summary of your testimony here today?
Yes, sir.
Let's talk about another topic, and that topic is a reality for expert witnesses like yourself, and that's payment of your fees and reimbursement of your expenses. We have a contract, we have an agreement in that regard, do we not?
Yes, sir.
And what is the hourly rate that you're charging the district attorney's office?
I charged $500 an hour for activities that I could conduct on my own schedule in my pajamas. I charged $650 an hour up to 10 hours a day for activities that are scheduled.
And there's also the reimbursement for your expenses, correct?
Correct.
All right. Is that standard in this line of work, this type of?
It's consistent for emergency physicians. It compensates for it. If I were to, instead of testifying, treat patients in the emergency department, it's close to what I would receive from them.
And that compensation or reimbursement, has that in any way affected your determination in this case?
No, sir.
Do you have any conflict of interest, a personal stake in the outcome of this trial?
No, sir.
In fact, you've signed a conflict of interest disclosure. Let's move on to, well, let's talk about it. Quicker than I thought. The studies was the next thing on my my list. I think as I work through this, outline. Looks like we talked about if there's anything that I left. The next thing here is injuries associated with shaken baby syndrome. And there was testimony yesterday from Dr. Galasnik that there would be or should be either a broken neck or a rib fracture or some ligament damage associated with a case of shaken baby syndrome or abusive head trauma in an infant. Is it necessary to always have that in conjunction with the shaken baby?
That suggestion is outrageous. The best study that performed MRI studies of children who experienced abusive head trauma did not find injuries to the neck in all of those children. And Kalen did not have any tests to see if he had injuries of his neck, except for a physical exam looking on the outside and an autopsy that was performed 9 months later, when the sorts of injuries that are alleged to occur commonly in abusive head trauma would have healed at that point. I find that not convincing.
And just to follow up on that, is it your testimony that it's possible to shake a baby to the point of serious injury without having those, either the neck injury or the fracture or the ligament? Biomechanical modeling is the next topic I'd like to talk about. Instructive or not?
Absolutely useless.
I'm assuming you're referring to the limitations with regard to biofidelity.
The human brain is one of the most sophisticated and complicated things in the known universe. To try and represent this like we all experienced in high school physics, like a pendulum, where we know how long a neck is and how heavy the pendulum is, and we can experience the forces that happen to that brain for a known mechanism, is ridiculous. No one, there's no biomechanical engineer on the planet that could watch a replay of an NFL football game and see two players hit each other and know what's going to happen, whether one of those players is going to have a concussion or a subdural hematoma or anything else. Now take that and add the fact that everybody's different, children grow and they develop. And, in shaking, there are multiple episodes of force that goes back and forth. Someone who just did one thing would say you can't break a paperclip by bending the metal. After all, paperclip is bent when it turns into when it becomes a paperclip. But no one who's been bored and fidgeted as much as I would suggest that you can't break a paperclip by bending the metal, because metal fatigues. There's this story. I can't find it, so it may just be a story. It may not have actually happened, but it's instructive to think about it. Was that some brilliant mathematicians and biomechanicists studied carefully and proved that bumblebees can't fly. They're too heavy. Their wings are too small. Now, do you counteract that by looking at their math? Do you see what they've done to experience it? No, you just show them a bumblebee flying and say, your biomechanical model does not make sense. Anyone who says you can't shake a baby hard enough to hurt their brain is not someone who, like I have, has had people confess to them that they shook a baby or that they harmed a baby. No one would, see a child that's normal at 1 minute and then 8 hours later is neurologically devastated and say, oh, maybe it was this minor thing where they hit against the door. Here, let me show you the math. It just doesn't make sense with what we see in the real world.
Is it fair to say that biomechanical modeling may be better suited for other applications, say for instance, accident reconstruction, or to reconstruct an accident or an incident at like a industrial refinery?
I'm sure I shouldn't go overboard. I'm not trying to say that the whole field of biomechanical engineering is useless. There are certainly things that can do, but for someone to say, I've shown you the math, you can't hurt a child by shaking it, it just does not convince me.
Because unlike with the accident reconstruction where you've got skid marks for a certain distance, you can test the strength of the tensile strength of the metal in the vehicles, or in a pipeline industrial facility where you know what the pressure was going through that pipe before it exploded. There are unknowns when it comes to modeling infants.
Absolutely. Abusive head trauma is far more complicated than those examples you gave. And those examples are not meant to say what's going to happen in one case. They're going to say, generally speaking, if you put a crumple zone in your Volvo, you're less likely to have an injury. But they're not going to say it's impossible. They're just going to say this will reduce the force, this will improve survivability, but it doesn't tell you what's going to happen in the next crash that comes into my emergency department.
Animal studies, crash test dummies, are those apples to apples comparisons with infants?
Animal studies aren't perfect, but I think there are some useful animal studies that show that you can have brain injury and eye injury from shaking. And of course, there's the literature on adult victims of shaking, which demonstrate that you can get subdural hematomas and retinal hemorrhages and brain damage.
Kalen's brain damage in this case, you talked about it, but if the court will indulge me, I think it's worth mentioning again. Kalen's brain damage was not the result of pressure from a subdural hematoma pushing the brain out of the skull, or what's referred to as herniation, right?
Correct. Sorry, there was one read that suggested maybe there was some herniation, which would not have been from a subdural pushing on the brain, but may have been the swelling and the brain injury itself.
Okay, and that was the tomato.
And I'm not sure if there was herniation.
And that was part of the discussion about the tomato in the container. So I'll move on. Dr. Galaznik yesterday theorized that a possible alternative cause in this particular case was it a epidural hematoma that ultimately led to intracranial venous thrombosis, a clot. What are your thoughts on that?
Well, if the epidural hematoma would have been significant in this case, I would have expected that to have been read on the CAT scan, because while there are small epidural hematomas, an epidural hematoma that's going to put pressure on the brain would be big enough to be seen on the CAT scan. And again, a cerebral sinus thrombosis wouldn't cause all the injury throughout the brain that we saw on the very first CAT scan that Kalen had.
And speaking of CAT scan, I understand in your line of work, you would frequently refer or consult neuroradiologists, right?
Yes, sir.
In order to review and make a determination as to what is actually shown on that CT or that CAT scan, correct?
Right.
While you may be able to make some, you may be able to, you may have an opinion, but who, in your opinion, would be better suited for making a determination based on that CT or that CAT scan, a neuroradiologist or some other practitioner?
I don't want to overgeneralize. In general, a pediatric neuroradiologist is extremely well trained, and that's their main job, is to interpret pediatric CAT scans and MRIs. And if I have a question, I definitely have a very low threshold to talk to my pediatric neuroradiologist.
And that would include making a determination as to whether or not a CAT scan shows a transverse sinus thrombosis that resulted from an epidural bleed that triggered brain swelling. Is that fair to say?
I mean, I'd like to think I could probably, in most cases, tell whether there's a transverse sinus thrombosis. But if you had two doctors who disagreed and one was a pediatric neuroradiologist, smart money would probably be on them.
The next question in my outline is to kind of walk through the 2025 NARANG, American Academy of Pediatrics Reaffirmation. But you co-authored that, right? So
I was not a co-author on the 2025 study. I worked with Dr. Narang in a previous study. Let's please not walk through all 7,000 references.
I think that should allow me to do that, but that would have been the 2016
I think that's the one, yes.
study that you worked with him on. But essentially the 2025 just reaffirmed the generally accepted practice as it relates to diagnosing shaken baby syndrome.
Nothing's perfect, but I consider the Narang 2025 consensus statement to be the most current statement about abusive head trauma, and it's been endorsed by many, many organizations. And so I would take everything in that paper very seriously.
All right. And lastly, the theory behind and the diagnosis of shaken baby syndrome and abusive head trauma in infants, that, in your opinion, remains generally accepted by physicians who encounter that type of abuse on a regular basis.
It's not just my opinion. We did a survey on it, and clinicians who are apt to treat children who might have abusive head trauma overwhelmingly agree that shaking can cause brain injury, subdural hematomas, and retinal hemorrhages.
Very good. Thank you, Dr. Lindbergh. Judge, I'll pass to you.
Thank you, Mr. Coleman.
Thank you, Your Honor.
Go ahead, Mr. Udison.
Let me get my stack out of the way. Dr. Lindbergh, I'm Gary Udison. We have not met. And
not meeting you.
I am one of Mr. Garner's attorneys. Let me start. I know you've written a lot.
Dr. Lindberg's testimony reveals a fundamental tension in post-conviction relief cases. Courts must decide whether new science actually disproves old evidence or merely offers a different perspective. The bumblebee analogy captures this perfectly. Models can fail while reality persists. Under Michigan's post-conviction rules, Garner must show more than academic debate. He needs proof that the original medical testimony was scientifically invalid, not just contested.
And I've read some of the things you wrote, and I may be getting you mixed up with somebody else because I've been reading a lot about this. But did you write something criticizing doctors who testify that there's new science in this area because they're getting paid to come to court and to review these cases? Am I remembering that correctly?
I wrote an article talking about whether there was new science and going through some of the theories. I don't remember if I criticized people for having a conflict of interest, but I certainly think that people who testify with a conflict of interest, have a problem.
But am I remembering correctly that you were specifically criticizing people for getting paid money to review cases and to come into court?
I don't think that's what I meant to say.
Okay, but you think you said something that I'm fairly remembering like that?
I would have to review the article. I will say that someone who writes a paper based on cases they reviewed for court and doesn't disclose the fact that they encountered it in that respect and that they were paid to testify, I think that's a problem of scientific misconduct. I understand that expert witnesses get paid.
Okay, but you understand, I'm asking you just if you are critical of other doctors getting paid to do exactly what you're doing today.
No, I'm not critical of the idea of getting paid for expert witness case reviewer testimony.
And are you aware that Dr. Galasnik is not getting paid anything for his involvement in this case?
I wasn't aware.
Okay, and certainly so you and him are in a completely different category as far as payment goes on this, right?
I'd like to think I'm in many different categories from Dr. Galasnik.
But you certainly are in the category making a whole lot more money than Dr. Galasnik.
Today, I believe I'm getting paid. If he's not getting paid, then I'm getting paid more than he is to be here.
Okay. Now, what were you told was the whole purpose of us being in court today? What's your understanding of what this is all about?
My understanding is that Mr. Garner is petitioning the court to review his conviction on the grounds that based on new science that has become available since his initial trial and subsequent petition, the initial testimony at his trial is false. And so therefore his conviction shouldn't stand.
Did anybody tell you that what this is about is whether there's new science in the area of shaken baby syndrome? Very specifically, the question is there new science concerning shaking alone? Did anybody tell you that that's really what we're here for?
I think I read a brief by you that suggested that was an important question.
Okay, but nobody said that's really the only question. Nobody told you that.
No one told me there was only one question.
Because it sounds to me like, and I'm not criticizing Mr. Coleman, it sounds to me like he didn't tell you even what we were here talking about, because you're giving testimony way beyond the question about whether or not shaking, whether or not there's new evidence that questions the theory that shaking alone can cause the particular injuries that we talk about in these cases. He didn't tell you that, did he?
If you're suggesting that there's only one question that we're here to address today, that would be news to me.
Okay, so
And I'm gonna just.
I'm sorry.
There's not only one question.
Well, I'm simplifying it, Judge.
Okay, so well, I mean, I don't want the doctor to be misled. The Court of Criminal Appeals has given me a couple of questions and some leeway as well, so.
I understand, but you understand, I mean, maybe you don't understand, but that Mr. Garner was convicted on a theory and argument that he shook this baby. Didn't do nothing else, just that he shook the baby. Do you understand that?
Sorry, you're suggesting that if Mr. Garner did something else violent other than shaking, he would not have been convicted?
I'm telling you that I'm telling you that when we are in court, people, and I think you probably understand this, people are charged in an indictment with a crime that sets out what the state is accusing them of doing. It's set out, if you were accused of a crime, you would have notice specifically, this is what they say you did. And then when you come to court, that's what the state has to prove. That's what the evidence they present is designed to prove. In this case, what I'm telling you is he was accused of causing injury to this child by shaking. That was the issue at trial. That's what the jury convicted him of. Were you aware of that?
Yeah, I'm not clear how specific it has to be. So for example, if I'm convicted of killing my wife with a baseball bat and I say, ha, I used a cricket bat, does that mean I'm not convicted?
If just follow me here just for a moment, that the state makes an accusation and that's what they have to, and the accusation here was that he shook this baby and that's what happened to the baby. Now, all I'm asking you right now is, did you even know that?
Yeah, my understanding is not that, I did not understand that his conviction is based on the specific violent act he performed.
Okay, so my questions really from here on out, the reason why I brought that up is because my questions are going to be about that. Okay, what I am going to be asking you about is the concept of shaking alone. Now, I'm sure you know that there is a controversy in the medical field, in the biomechanical field, in the legal field, in the courts. There is a question as to whether or not you can cause the particular injuries we talk about in these cases by shaking alone. You're aware of that controversy.
I don't accept that there's a controversy in the medical field.
Okay. Okay. Well, you're aware that courts all over the country, including in Texas, think there's a controversy. You're aware of that, aren't you?
You asserting that there's a controversy means that someone thinks there's a controversy.
Are you aware that there are courts are you aware that there's courts in Texas, New Jersey, Michigan, Arizona, Illinois, New York, Maryland, that courts from all over the country have found that there is new science concerning the issue of whether shaking alone can cause the injuries in this case? Were you aware of that?
I'm not aware of what those courts have found. I am aware that people have asserted that there's controversy about shaking in courts.
And so you have never heard, and I understand you're not, I guess, are you a pediatrician?
No, I'm a general emergency physician and I'm a member of the child protection team.
But you're also are you a certified child abuse pediatrician?
I'm glad you brought that up. I'm not allowed to sit for the board certification exam in child abuse pediatrics because I'm not a pediatrician, but I have taught at that course, I have done the fellowship, and I do practice on a child protection team.
So you go to those meetings, you talk to people in that field as part of your professional life.
Next week.
And are you telling me that at the meetings of the child abuse pediatricians, nobody's talking about what's going on in the courts around the country?
People are certainly talking about what's happening in the courts around the country.
Okay, and you're going next week to a meeting.
Yes, sir.
And I assume next week in the meeting, they'll probably be talking about the Rourke case from Texas. Have you heard of the Rourke case from Texas?
I have heard of the Rourke case. I read about it in review for this case. I don't think we'll be talking about that at the meeting next week.
Well, do you think y'all will be talking about the Neves case from New Jersey? You're familiar with that one.
Sorry, I should say, this is a case for clinician scientists who study child abuse pediatrics. And so, well, people may be upset that cases are going to court on really flimsy science, and they may talk about that. That's not going to be the subject of the meeting.
Okay, so forget the meeting. Are you familiar with the Neves case from New Jersey? You know what I'm talking
I'm not,
about?
no.
Have you heard that there was a case in New Jersey where an opinion came out from the New Jersey Supreme?
Him knowing about case law that got us here, I don't think is getting us to the questions that I'm.
Okay, well, I understand, Judge. I'll move on. Doctor, you seem to have a extremely strong feeling about biomechanical engineers.
Oh, I have nothing personal against biomechanical engineers.
But you think it's a flimsy profession that we shouldn't be listening to.
Oh, no, I credit my survival in my last car crash to bioengineers. I don't think you should apply bioengineering principles to determine what mechanisms could have caused Kalen Garner.
Have you ever done a medical study where you have done some actual physical work like biomechanical engineers do to try to determine if you can?
The defense attorney's cricket bat versus baseball bat analogy exposes a critical procedural issue. Post-conviction relief often hinges on whether new evidence undermines the specific theory the jury actually accepted, not merely whether the defendant might have been convicted under a different theory. Under Michigan's post-conviction framework, courts examine whether the original trial's factual premise here, that shaking alone caused the injuries, has been scientifically invalidated, or whether the science merely remains contested.
Cause the injuries we're talking about by shaking. Have you as a medical doctor done that?
No, sir.
But you don't think a profession that does that is something we ought to listen to?
The reason I haven't done those studies is I don't think that's a reliable way to get to truth. And we're asking what mechanisms could cause an injury to a child.
So
That's one reason I haven't done it.
if I'm understanding correctly, you're telling us that scientific studies are not reliable compared to the experience of practitioners.
So that's a mischaracterization. That is not his testimony. He didn't say scientific studies in general.
I'll rephrase that, Judge.
Thank you.
You're telling us, Doctor, that scientific studies by biomechanical engineers are less reliable than practitioners like yourself just coming in and saying, I know it when I see it.
That's not what I'm saying.
You said, well, you are saying though that confessions are more reliable than biomechanical engineering.
I just want to be careful not to overgeneralize. What I'm saying specifically is that biomechanical studies cannot tell us what happened or whether shaking can cause brain injury compared to all the other forms of evidence that suggest that shaking can cause brain injury.
Okay, so the other forms of evidence you mentioned, one of them was confessions, right?
Sure, yeah.
Okay, so you think the confessions that people allegedly have made to shaking, you consider that to be more of a valid source of information than biomechanical engineering studies?
I think that's fair. I will say people have confessed to me of injuring their children by shaking.
Okay, so if you say, if you are a police officer or another doctor says to somebody, says, this baby was shaken. You tell them, I'm a doctor, this baby was shaken. Or the police say to an accused person, the doctor said this baby was shaken. And then that person says, okay, I shook the baby. Is that a valid confession?
I don't know which confession you're talking about.
I'm talking about a hypothetical confession. I'm sorry.
If I may, I'd like to object. I don't know that that's appropriate or outside of the realm of the expertise of this witness to testify about the appropriateness of or validness of a confession or not.
I'll rephrase this a little bit.
Thank you.
I know you know Dr. Ed. Were you aware that we did a deposition a couple of months ago in Austin of Dr. Edwards for about 3 hours that was all about confessions? Were you aware of that?
I wasn't aware of that.
And of course, you do know that Dr. Edwards is the lead author on the leading article in the child abuse pediatrician world about confessions. You're aware of that, aren't you?
I'm not remembering the article specifically, but I do know that Dr. Edwards has published important articles.
But you're not, I guess in the deposition, I asked Dr. Edwards if he would consider his article to be the leading article in the field about confessions. He was pretty humble, but he said, I guess you could say that. But you're not aware of that article, no?
I'm not.
Okay.
I mean, sorry, I'm sure I've read Dr. Edwards' article. I can't remember the specifics of it off the top of my head.
Okay. So if you were
The defense attorney is probing a crucial tension. Courts nationwide are increasingly skeptical of shaken baby syndrome convictions. Yet the state's expert dismisses this as irrelevant to medical science. This mirrors broader post-conviction battles, where legal challenges to forensic science often run ahead of professional consensus, leaving defendants caught between evolving law and resistant institutions.
looking at would it surprise you to learn that when all of the information about confessions in shaken baby syndrome cases is gathered together, that a very significant number of those alleged confessions are people saying things like, my baby was not breathing, so I shook him a little bit to get him to breathe. I mean, you're aware that that's thrown in there as confessions.
I'm certainly aware that some people faced with doctors or police officers who say the only way these injuries could have happened is because someone, you shook this baby, will say, well, maybe I shook them to revise them. Or in this case, maybe I shook them to get their attention or to see if I could wake them up. And I don't use that sort of evidence in this case to conclude that Kalen was shaken.
Because that's not a real confession, is it?
I can't opine about
about the validity.
What, can I respond?
The defense attorney exposes a troubling circularity. Confessions extracted after medical accusations become evidence that validates the original accusation. This mirrors documented problems in false confession research. When authority figures present false evidence, innocent people often comply. The attorney's reference to Dr. Edwards suggests the defense has invested significant resources in deconstructing this methodological foundation.
On to that, Yara.
Yeah.
He said that he relies upon confessions to say that it refutes the biomechanical engineering studies. So I want to test him and question him about what he knows about confessions and what he considers to be a confession.
Well, I mean, I think I'm going to let you go a little bit into this, but he's also specifically testified that that's not the only thing that he takes into consideration. And specifically just testified that it's not what he took into consideration in forming an opinion in this case.
Well, my point is I'm questioning his dismissal of the biomechanical engineering studies.
I think I've got a good grasp of what you want to do and where you're going with that, and my understanding. I don't think you need to go a whole lot
Okay,
further.
all right, that's fine. Thank you.
Yes, sir.
So I assume, and I don't mean to be personal or flippant, I assume that when you were 18 years old, your life was quite a bit different than Luther Garner's life when he was 18 years old.
I suspect that's a very fair statement.
You were probably a freshman at Harvard University, right?
Yes.
And Luther Garner, when he was 18 years old, had grown up in a rough household with a mother who apparently had a drug problem.
The defense has found a crack in the state's original case. Dr. Stein testified at trial that shaking alone and nothing else caused the injuries, yet two subsequent experts, including the state's own Dr. Yu, won't endorse that certainty. This matters because post-conviction relief requires showing that new evidence would likely change the outcome. If the original conviction rested on medical certainty that no longer exists, that's precisely what habeas corpus proceedings are designed to catch.
People for getting paid money to review cases and to come into court.
I don't think that's what I meant to say.
Okay, but you think you said something that I'm fairly remembering like that?
I would have to review the article. I will say that someone who writes a paper based on cases they reviewed for court and doesn't disclose the fact that they encountered it in that respect and that they were paid to testify, I think that's a problem of scientific misconduct. I understand that expert witnesses get paid.
Okay, but you understand, I'm asking you just if you are critical of other doctors getting paid to do exactly what you're doing today?
No, I'm not critical of the idea of getting paid for expert witness, case reviewer testimony.
And are you aware that Dr. Galasnik is not getting paid anything for his involvement in this case?
I wasn't aware.
Okay, and certainly, so you and him are in a completely different category as far as payment goes on this, right?
I'd like to think I'm in many different categories from Dr. Glass.
But you certainly are in the category making a whole lot more money than Dr. Galasnik.
Today, I believe I'm getting paid. If he's not getting paid, then I'm getting paid more than he is to be here.
Okay, now what were you told was the whole purpose of us being in court today? What's your understanding of what this is all about?
My understanding is that Mr. Garner is petitioning the court to review his conviction on the grounds that, based on new science that has become available since his initial trial and subsequent petition, the initial testimony at his trial is false. And so therefore his conviction shouldn't stand.
Did anybody tell you that what this is about is whether there's new science in the area of shaken baby syndrome? Very specifically, the question is there new science concerning shaking alone? Did anybody tell you that that's really what we're here for?
I think I read a brief by you that suggested that was an important question.
Okay, but nobody said that's really the only question. Nobody told you that.
No one told me there was only one question.
Because it sounds to me like, and I'm not criticizing Mr. Coleman, it sounds to me like he didn't tell you even what we were here talking about, because you're giving testimony way beyond the question about whether or not shaking, whether or not there's new evidence that questions the theory that shaking alone can cause the particular injuries that we talk about in these cases. He didn't tell you that, did he?
If you're suggesting that there's only one question that we're here to address today, that would be news to me.
Okay, so
And I'm gonna just.
I'm
okay,
sorry.
There's not only one question.
Well, I'm simplifying it, Judge.
Okay, so well, I mean, I don't want the doctor to be misled. The Court of Criminal Appeals has given me a couple of questions and some leeway as well, so.
I understand, but you understand, I mean, maybe you don't understand. I mean, maybe you don't understand, but that Mr. Garner was convicted on a theory and argument that he shook this baby. Didn't do nothing else, just that he shook. Garner was convicted on a theory and argument that he shook this baby. Didn't do nothing else, just that he shook the baby. Do you understand that?
Sorry, you're